Hello, everybody. Just wanted to make sure everybody knew I am here. We're waiting for things to set. Uncivil Law is actually going to be joining me soon. 1 second. Got to mute. Stop that. So we are going to be starting soon. I'm just waiting for everything. Just getting some coffee. I had the coffee machine going. Let me go back to stream. There we go. So I got the coffee machine going. So yesterday was a very good day. David is killing me. Yes, David. Yes. See, David was hating on me yesterday. Nate was wrong, blah, blah, blah. But then after he sat here and watched for a while, I think I've turned David into a fan. So thanks, David. Thank you. So you're back now. Huh? You're back for some more of the pain, huh? So as everybody know, yesterday, um, it seems like everybody liked my thought process yesterday going into the cross examination. So just so we're clear about what's going on today. Everybody, for everybody who doesn't understand the joke, yesterday we were evaluating the cross examination, and for some reason the defense was letting the witness just give a speech. And so he was like, "Was the car blue?" And the witness would just go into this long speech. So we're like, just keep him to a yes or no. Keep him to a yes or no. So that's why everybody's saying that. So today, what do I expect? I expect the defense to put on their case. But we're going to see reversal here. We're going to see the defense not asking a lot of those yes or no questions. They're going to be asking a lot of open-ended questions. What is your opinion? What's this? What's this? And we're going to see the prosecution then go into cross-examination. You're going to see them really ask very specific questions. And again, remember, cross-examination, the witnesses, it's less of the witness testifying than the attorney testifying. So we'll see that dynamic. What do I expect today from this? Simple. Let's just keep it nice and simple. We expect the defense to bring a witness that says what Chauvin did was reasonable under the circumstances, was justified under the circumstances. I expect them to say the crowd was a factor. The crowd was a huge factor, right? Because they're trying to render aid, but you have a hostile crowd. I expect them to attack the injuries and, the lack of injuries, cause of death. Remember, the defense doesn't have to prove, and I think a lot of people have to understand this. This is a key point to this whole thing. The defense has to prove nothing. Nothing. They don't have to prove anything. They just have to make it so confusing. Did he die of a heart attack? Did he die from the police restraint? Did he die from meth? It's so many different things. I have a doubt, right? I have a reasonable doubt. These experts say he died from fentanyl. These experts say he died from the police restraint. These experts say he died from a heart attack. You know what? Too many experts, too many different things. That's reasonable doubt. That's what the defense is going for. Prosecution, on the other hand, what they are going for, very specific. You need the prosecution saying the cause of death was Chauvin. The cause of everything's very specific. The cause of him. Defense, we want everything to be a cause, right? It could be this, could be that. So that's what you're going to be looking for today, and that's what that's what you're going to be seeing going into this. So we'll be back. Uncivil Lord's in the chat for some reason because I sent him the link on Facebook. So, if you want to come in here, bro, you can. If you don't, I'm going to grab some coffee. This should be starting in a couple of seconds. I should be back in 5. Hang out and we will see. But yesterday, for those who challenged my legal acumen yesterday, remember, I called that cross-examine yesterday. I called it straight up. Here we go.
Hey, good morning, everybody. We're on the record. We are outside the presence of the jury to discuss the admissibility of the body-worn cam of which witness is it, Mr. Nelson? All right, and I have had a chance to review it. Mr. Frank, the state had an objection.
Good morning, Your Honor. Yes, we do have objections to the body-worn camera video.
Audio is better
as I
than day
indicated
two.
to counsel last night, we would object to admission of Officer Chang's body-worn camera video after the time stamp of 1:15:35. That, as I think I tried to point out, is that Zulu time thing rather than the regular time that the MPDs are in. But it's also running time 5:12 on the scale below. Within that first 5:12, there is a particular piece that we need to talk about because Officer Chang sits in his squad car and runs Mr. Floyd's name while his body cam is looking right at the screen. And information about Mr. Floyd pops up. Some of that is actually you're able to read. And because this, if it's made an exhibit, would be public, we think it's inappropriate to have information about Mr. Floyd on that screen available as an exhibit or generally to the public. So somehow that has to be obscured. We don't care if a black box is put over it, if it's obscured in some way, but it's within that portion of the rest of the video we recognize is admissible and relevant. Because that time frame is the incident itself. Officer Chang arrives, interacts with the two officers and Mr. Floyd as they go over. After Officer Chang comes back over to the Dragon Walk side of 38th Street. He admits in a statement he no longer sees what's going on over there. Because this is a reasonable officer standard, as we all know, what happens after the restraint and across the street on 38th is simply irrelevant to the issues at hand. So after that point in the video is where we believe it reasonably loses any relevance. After that point, of course, there's audio, and Officer Chang speaks to the two individuals that were passengers.
Thanks for the
and
$5 super
it's just
chat
full of
for the
hearsay.
mic drop yesterday.
Some of that would be offered to prove, we believe, the truth of the matters asserted in those statements about what happened. So it's full of hearsay after that. There is a moment where Officer Chang towards the end is standing around as the officers do some follow-up, and this court allowed video of that time period as relevant to conducting or finishing their investigation. So I see where the court might find that particular period of Officer Chang's video to have some relevance. So in that sense, we would object to that portion, really as cumulative, because of course, the better video of that has already been admitted with Officer Chauvin's body cam during that time period when Officer King comes out. I believe that was the court's ruling about why that's relevant. It shows something about the intentions of their investigation. So our objections are being able to read the screen in Officer Chang's squad car if he pulls up the information about Mr. Floyd.
I might give him that.
1:15:35 is simply not relevant. It's full of hearsay and potentially a cumulative objection.
I don't know. I don't know about that one. The first one, yes. The first one I can see. The second one, yeah.
Bystander video of the bystanders near the Dragon Walk, who were the people that Mr. Floyd was with earlier that day, or earlier before this going into the store. How is it different from the bystander videos that the state offered and played with regard to statements that were made?
The video should be in. The
other
screen, no,
bystanders
but the
are
video
part of
should
the
definitely be
incident.
in.
Certainly the defense, has regularly cross-examined about the tone of voice of those bystanders and their effect, apparently, on Mr. Chauvin at the scene. They are part of the incident itself. They cannot really be separaed from.
Yeah, John is correct. They're arguing
issues
cumulative
involved
now.
in the restraint and
The whole
reasonableness
thing has
of
been
it.
cumulative. That's
And
true.
I fully expect that's why there was no objection to that. This is a video of across the street. In my review of the video, you can't even hear what's going on in this video until the ambulance has come and gone, and one of the witnesses starts to walk this way, towards the Dragon Walk.
Now,
So
for
it
most
does
of you
not capture
who are
the
not
relevant
legal scholars out there,
interactions
relevance
and
is
portions
extremely
of
low standard.
the
It's if it's relevant to a fact of consequence. I think that video is definitely relevant. He's making also a hearsay objection. If I were the judge, I would let it in. The first one I wouldn't let in. The second one I would definitely let
Thank you,
in.
Your Honor.
The defense
Your
got to
Honor,
be
I
able to
would,
prove its case.
break Mr. Chang's video into kind of three relevant sections, or three pertinent sections, I should say. The first being the initial reaction as described by Mr. Frank, the first approximate 5 minutes of the video. And then there is a period of time, a second period of time where Officer Chang is dealing with the passengers. And then the third part of the video I would characterize as the occurrences after the ambulance has arrived and left and what happens there. In terms of the first section, I do believe that it is relevant to the analysis. It shows another perspective of what was happening at that particular moment. I would need to
Yes,
figure
they're
out
going to
fairly
blame the
quickly,
bystanders.
how
Yes,
to get
that's what's
that
going to happen.
blocked, how to get those
They're saying the
portions of
bystanders
computer screen blocked.
was effect.
That
Was an
contain,
effect. Yes.
Information about Mr. Floyd. There's that section. I don't think, subject to that redaction, I don't think the state apparently objects to that. The second part, I believe, is relevant because it shows another officer's reaction to what is going on. It shows other bystanders' reactions to what is going on. And you can see during that period that Officer Chang is pacing kind of back and forth, trying to split his attention between the passengers and also observing what's happening across the street. Again, in terms of the reaction to the crowd and the crowd growing more and more vociferous as time progresses. So I do think it's relevant because it shows it from a distance. It shows Officer Chang walking. It shows at scenes where people are standing on other sides of the street. It shows the traffic. It shows people slowing down and watching. There's a lot of information that can be gleaned from that segment. The third segment, I think, is also relevant because it demonstrates, again, the continuing efforts of the police and also the continuing interactions with the citizens who observed, and goes to, as is being alluded to, is that if the crowd was a distraction or the officers perceived this gathering of people, whether we want to call it a crowd or a group or whatever, whether the officers perceived that to be a risk or a threat, and how that may have continued and ultimately influenced officers' decisions. So I believe it is highly relevant. I do not believe it is hearsay in the sense of you don't hear anything, essentially very little that the officers say. The officers don't talk about what just happened over there, with one small exception relevant to Mr. Williams and Miss Hanson. There's some comments there. I believe that part may already be in one of the other body cameras. I'd have to go back and double check. That being said, Your Honor, I don't think it's cumulative because it again shows a different perspective. It shows a reaction of another police officer and what he was doing. It shows the surroundings from a different perspective and is highly relevant to the trier of fact.
I have reviewed the entire thumb drive that contains the exhibit. And I do find that it is relevant and not cumulative to a certain point. I would note that the body cam includes video from a distance, what is happening in front of Cup Foods, but also the timing of when the fire engine 17 shows up. And since the emergency EMS response has been litigated in this case and is relevant as to when EMS showed up, when the fire engine showed up, firefighter Hanson specifically described how she would assume it'd be within 3 minutes. This puts that in a time frame on the EMS call, and so that is relevant. And to the extent that there are any statements made, I find they're not offered for the truth of the matter asserted, or to the extent they are, they fall into the residual exception because these are people just making comments of their observations at the scene. There's no motive for them to lie or anything else, so they would certainly be reliable. They're not inculpatory in any way. And so I think it would fall into the 807 residual.
Present state of mind.
Even if it is
present sense impression.
Matter asserted, but it does not appear to be that the state is trying, or the defense is trying to prove the truth of the matter asserted. So with that, I'm going to order that you redact the part when the officer is looking up on the
I should put a
computer,
robe
for
on
today's purposes,
because I've been
you can
calling this
simply
thing
fast
straight
forward
out.
through it,
How
30 seconds or so.
this is the
when
best
you
legal commentary on YouTube right here.
When you get to that,
It's almost like you know what you're talking about.
Do I?
That way,
Do I?
the jury won't see it when you publish
The
it
judge
today,
is the judge going to
but
rule
it's gotta
exactly
be
how I
redacted.
thought, how I would
You gotta
rule?
take it back, and before we submit this to the jury for deliberation, it has to be taken out. So basically, when he gets in the squad until when he gets back out of the squad.
Yes,
And I'll
yesterday.
advise him that it's been edited to take out irrelevant materials.
Look at that. On the
Up
money,
until
right?
The time the fire engine
Look at
leaves.
this. Look at this.
Anything after
Humble
that is
Nate.
not really relevant.
Humble, what
to
are you
some extent.
talking
It is
about? You come down, you
cumulative, as the
come here
state
for
has
legal
said.
commentary.
But up
The judge is
through the
ruling
time
exactly.
the fire engine leaves is appropriate. So
There it
with
is.
that redaction in the middle and the ending after the fire engine leaves, the body worn cam will be admissible.
It's like, how would you know that, right?
Minutes accomplished
Who would
that.
have thought? The
All right.
judge would-
You can actually accomplish the redaction within 10 minutes.
Cutting
Boom.
those clips out rather than trying to put some sort of black screen on.
Now that would be my preference.
So if I can have about 10 minutes, Your Honor.
Let's reconvene now. Let's bring the jury back at 9:30, and we'll start at 9:30. Yeah. This is your copy, Mr. Nelson. We'll reconvene at 9:30. Anything else that we need to go over? All right, we're off the record then.
All right. Thank you. So we're better than the people. This is my brother on civil law, for those of you who don't know. So this morning we watched part of the motion, and again, I called it exactly how it was. I said the redaction makes sense because you don't want personal information. Then right behind it, I said the video is obviously relevant. It moves a fact of consequence, right? It's relevant to a fact of consequence. The judge said the same exact thing. Video comes in, exactly what was predicted. So the defense now has got to put on its case. On civil law, what's going on, my brother?
Not much, man. Yeah, you're calling it pretty well. Like you might know what you're talking about sometimes. Yeah.
That one thing for all you people out there, there's been a lot of I don't want to call it misinformation, but confusion. There's a lot of confusion out there. For those of you who watch both me and Robert Barnes, and no, I know, but I just want to make a couple of things clear. Robert has made some critical mistakes when analyzing this case. The first critical mistake he's made is that he says that assault can't be used as an underlying felony for felony murder, right? That is wrong factually. And Robert, to his credit, has realized that and now admits that assault can be used as an underlying felony for felony murder. So essentially only thing they have to do is prove Chauvin assaulted Floyd, and then you got felony murder, right? The murder was a commission.
Didn't he call you names when you made that claim? Didn't he basically call? Yeah, he called. It's like yeah. And now he's like, oh yeah, actually it's true after the whole time. Yeah. Unbelievable.
But the second thing that Robert has made a huge error in, and I think is confusing a lot of you people out there, is that Robert has made the issue that the prosecutor has to prove that that Chauvin intended to cause Floyd serious physical injury. That is incorrect. That is wrong. That is not the intent that needs to be proven. That's legally wrong. The reason why is because assault is what is known as a general intent crime. So you don't have to prove that they wanted to cause the harm. You just have to prove that they intended to do the act. For instance, a different crime that's from a general would be like a specific intent crime. A specific intent crime would be something like theft. If someone takes something, the prosecutor also has to prove that they had the specific intent to deprive you of that property, to keep it, right, to hold it from you. That's specific intent. But with general intent crimes, if I slap somebody in the face and then they fall and split and their face gets split open, the prosecutor doesn't have to prove that I intended for your face to get split open. They just have to prove that I intended to slap you, and that intent to slap you, and I did slap you with the actus reus, then is enough to prove the assault. So here, they don't have to prove that Chauvin intended the harm that was to cause the Floyd. They just have to prove that Chauvin intended to assault him, intended to hold him down in the way he did, and was not justified. So that's a clarification. That's a legal clarification. And if you want to look it up, don't trust me, as I always say, go look up general intent crimes versus specific intent crimes. Look up YouTube videos. Everyone will actually tell you that. If you want to see the clip of Robert actually saying that, and he's wrong about it, I'll show it to you. But I don't want to destroy the man. But there's a lot of you people.
I do.
But there are a lot of you. There are a lot of you guys who are watching both of us and keep challenging me with Robert's interpretation of things. But he is legally wrong. He is legally wrong. You don't have to prove the person intended to harm someone when it comes to assault, because assault is a general intent crime. Again, don't trust me. Go look it up for yourself.
Well, I would say it depends on the jurisdiction here and how exactly it's written, because sometimes assault can be written as specific intent. So it depends how exactly it's written in the relevant statute.
Hey, it's possible, but all the literature, again, Google it for yourself. Google, general intent, and the first thing that comes up, general intent crime, is assault, right? It's just like, what is it? I want to say specific intent. It's just like if you ask for what's a strict liability crime. First thing that comes up is statutory rape. Statutory rape is a specific intent crime. General intent crime is assault, and specific intent crime or theft crime. So it also gets
a bit confusing because states are a little bit inconsistent how they use the term assault and battery versus the common law definitions.
Oh yeah, definitely.
So what the crime of assault and the crime of battery, like if we're going off the classic old school definitions, then in common law, then you would actually say that battery if I'm remembering correctly. It's been a long time, but I'd say
Mhm.
that battery is general intent and assault is specific intent. But this is old school common law. But the way that they're defining these crimes now, because the jurisdictions use the terms inconsistently with common law, you actually have to get into it and actually look at it. So there's a little bit more nuanced point there to be had. But the difference between general intent and specific intent is right. He's right as to that much. That in general intent, you just have to show that you did the requisite acts with the right mental state of performing the acts, not with the result in mind. So that's the distinction. In general intent, you intend to perform the acts, but not specific result. Specific intent, you perform the specific acts with a particular result in mind. So it depends on how the statute is written. If we want to be really, really geeky, precise on this thing.
Listen.
Is that too much law too early in the morning?
Well, hey, if just in case in Minnesota, I can pull up I can pull up a Minnesota attorney.
Yeah.
Who's going to tell you the exact same thing. So if you guys want to hear that, I can pull it up for you. But in Minnesota, assault is a general intent crime, just like in, I'll say 90% of the jurisdictions in America. Assault is a general intent crime. If you look up the definition of a general intent crime, if it's going to say an assault is a general intent crime, just like it'll say statutory rape, it's a specific intent crime. Now, maybe there may be some wild, reckless or whatever, jurisdiction that doesn't allow it that way. But again, it's clear. You can look it up for yourself. Assault is a general intent crime.
I'm not saying this because I want Robert Barnes to be right. You know that. I'm not trying to contradict you for the sake of it.
Oh no. Again, it's just like with the felony murder rule, right? Certain jurisdictions, certain different things. Since we have like 7 minutes, here is I'll play it. I think I have it.
All right.
Here it is. This guy is this is a criminal defense attorney from Minnesota, and he's talking about third-degree assault, which we're talking about here at the show. So this is what Chauvin is being charged with, and he's explaining to us whether it's a specific intent crime or a general intent crime. What's up? Mm-hmm.
So for substantial bodily harm that's defined under Minnesota law, it usually means things like broken bones, scars, stitches, or a temporary loss of consciousness or the loss of the functioning of an organ. So if you knock somebody out for a while, that could be a third degree, like broken bones, substantial bodily harm. They cut open and you never meant for that to happen. You can still slap someone and all you're thinking is you're going to hurt them on the face for a second. You actually have to.
Sorry, here is the clip. I had to get it to the right point, but here it is right now. Listen carefully, everybody.
Either have to intend to cause fear of bodily harm, or you actually have to intend to cause harm on them by hitting them or something. In Minnesota law, you don't have to actually intend that the injury be substantial bodily harm to be guilty of third-degree assault. So, for example, if you intend to just slap someone and all you're thinking is you're going to hurt them on the face for a second, leave a red mark, but instead when you slap them, their whole face gets cut up and they have to go get stitches, that's a third-degree assault, even though you intended only for them to get a red mark. Instead, they get cut open and you never meant for that to happen. You can still be guilty of third-degree assault because you don't have to intend the injury. You just have to intend to assault someone. And then if the injury happens and it's substantial bodily harm, then you could be guilty of third-degree assault.
Well, the way he's saying that, if you say intend to injure someone, he's talking, that still implies specific intent because he's trying to distinguish the way he's phrasing it between the desire to cause harm and the degree of the harm you intend. So the way he's phrasing it, he's saying you have to intend the harm, but if more harm causes than you intend, then you're still liable for that increased harm. But the way he's phrasing it still implies you have to have the intent to cause the harm, unless I misheard him.
Yeah, what you're trying to do, you're trying to put a square into a box that's just not there.
Yeah, so
what he's essentially saying is, you slap somebody.
Yeah,
that and you can prove the person intended to slap the person. That is the intent that the state has to prove. That's in 99.9% of jurisdictions. I'm not sure. Maybe this is just something that's unique to criminal law that people don't know what happens in criminal law. But that's what this person is saying. If you slap somebody and you don't, let's say you don't even intend to hurt them, but you slap them and they are harmed.
See, that isn't quite what I heard. I mean, I don't know how this would happen in the real world, but the way he phrases it, it would suggest that if I intend to slap someone without causing them harm, which I'm not sure how that's possible, but let's go with that. If I slap someone intentionally, but don't intend to cause them harm at all, then the way he's phrasing it would suggest there's no liability, at least in theory.
No, that's not what he's. That's not.
Okay,
The
well
only
then
thing you
I
have to
guess I
prove-
miss. all
Only
right.
thing you have to prove is the intent, right? The act. If I punch you but don't intend to harm you, but I do harm you, they just got to prove the intent to harm. Hold on one second. Let me share this again. Let me go back to this so we don't miss this. It's about to start up. So there it is. So all right, yeah. I want to make sure I put that back on the screen. Yeah. So it's not. So there is no specific intent there. You know, and I know it's difficult because it's confusing for people who are not criminal attorneys, right? Usually when you're getting into this far the weeds between specific intent and general intent and malice intent, a lot of people who are not criminal attorneys don't understand these nuances. But the simple fact is, with general intent crimes, I just got to prove that you intended the act. You intended to cause the act. It's very close to so honestly, it's very close to saying that the person just really has to have the actus reus. But you know, just look it up, Google it. Google what a general intent crime is. Google assault as a general intent crime, and it literally explains out exactly what I'm saying. You just got to prove the person intended to punch the person, intended to slap the person, and any harm that falls from that, that's where you get the assault. The harm is not. You don't have to prove the intent to harm. You just have to prove the intent to the act.
Okay.
Let me see. Accidentally. Yeah, if you hit somebody accidentally, you don't have the mens rea. I mean, actus reus is that if you hit somebody accidentally punching somebody is not. I'm saying a person intends to hit somebody, right? I slap you. I intend to slap you, but I don't intend to kill you. That would still be an assault. If I slap you and you die, and they can prove I intended to slap you, that's an assault.
Okay.
Barney, with this work, I intended to inflict any harm. I'd be liable for all the harm resulting. Correct. Yes. Thank you for the $25. Thank you, Barney. But yes, exactly what it is. And it's a little weird thing, but Barnes and I thought Barnes understood it because Barnes is obviously a criminal. He's defending Kyle Rittenhouse, so that's why I was kind of when he said it, I was like, well, hold on, this is not a general intent crime. Maybe, but again, maybe in the jurisdictions he practiced in, maybe you're right. Maybe assault is a specific intent. You got to prove the person intended to harm. That it's possible, but generally that's not the way it works. Oof. Who's HR? Oh, HRK. I'm not sure. Where's Barney from again?
Croatia.
Yeah. So what do you expect to hear? What do you expect to see today from the defense?
I'm not sure what I'm going to see today from the defense, but I assume that we're going to have the similar parade of experts, similar parade of witnesses to the prosecution. So we'll find, use of force experts, use of training experts, former police officers, former training experts from Minnesota, Minneapolis, who have training on this, use of the neck technique, how it's actually been taught in the real world, how it's been demonstrated in the real world, instances where it's been used in the real world. To go to inform his intent. We'll have people saying how the real world is not a book. There's the difference between the theory and practice.
Oh yeah.
And what the book says is one thing, and what the reality of it is different. And just because you might deviate from the book doesn't necessarily mean that it's a crime makes. That there's any number of situations where it can't account for reality of the situation. People pointing out more emphasis about how people make false claims about not being able to breathe or other conditions, so they fake. And the defense certainly alluded to this on cross in several places, but more about, because it's going to hit Chauvin's intent, right? About how police officers hear all the time about how someone is sick or whatever, so they don't go to jail. So they kind of are a little bit numb to it. They don't really hear it. And how Chauvin was even making those claims in the car. So even give further reason not to believe the claims, because it's all going to his mental state. So that's the kind of things that I would hear. I'd also point out people dealing with crowd control and how crowds influence situations, and how, you can only have your attention in so many places at once. Even Chauvin, for that matter, his attention was not and could not be on Floyd limitedly because of everything else going on. I mean, Chauvin would have been probably negligent, I'd hear testimony to this effect. I'd be sure that he'd be negligent for paying sole attention to Floyd, because he has to worry about the crowd and who might be rushing in and where his partners are and how that's going on. So that diverts his attention. He's worried about the crowd and what they're going to do or not. You know, trying to keep the scene secure, going to his mental state. So that's what I'd expect to hear.
Well, the interesting part is that for the first, just breaking this down into 3 sections, because and if just thinking about it from the felony murder perspective, obviously assault is a lesser crime, right? Assault is a lot easier to prove than manslaughter. It's a lot easier to prove murder in the 3rd degree. It's just assault. This is assault in the 3rd degree. It's a simple crime. So if we're talking about proving the assault, right? I think you got that. You know, Chauvin did this. He held him down. It's an intentional act. He intended to do this, right? He intended to hold him down, handcuffed, this. So as long as you can prove that he intended to do that, whatever.
Well, you
hold
do
on,
have a problem.
Let me finish.
Okay.
As long as the state can prove that that's intentional, that he intended to do that, then you have the assault. But now the state also has the burden to prove that that wasn't justified. So whenever an officer puts hands on somebody or arrests somebody, they are actually committing a form of assault, but they are justified in committing that assault under color of law. So when Chauvin did his act, it's now whether it was justified or not, right? Whether he was justified in doing that. So I think they do have the assault, but now Chauvin, and I think the defense team is going to be arguing that Chauvin was justified in both the amount of time and the amount of force that was used to make it so. In other words, instead of saying this was just a naked assault that was unjustified, he's saying that this was an assault that was justified based on the facts and circumstances, if you take them together. The crowd, the fact that he was resisting, all these things, if you take them into account, a reasonable officer in the same set of circumstances as you've been hearing about the Graham standard, a reasonable officer would have taken on to the account, would have done something similar. And again, when you're talking about a reasonable officer in the same set of circumstances, you don't have to do exactly the same thing a reasonable officer has to do, but with your actions have to be something that a reasonable officer would have taken into account. So just because you're saying a reasonable officer wouldn't have did the exact same thing, but what if a reasonable officer would have taken the same steps or done the same thing that you tried to do? Go ahead. Sorry about that. I wanted to just get that point out.
No, it's fine, and I can't remember what I was going to say anyway, so it doesn't matter.
Yeah. So right now the defense's whole argument, because again, I think if they're trying to argue this wasn't an assault, I think that's a loss. I think that's a loss. I think arguing this was not an assault is a loss. I think this was a justified assault is the win, and I think that's the win to go for.
Oh, sure. I mean, you have to argue that. I mean, what he did clearly is an assault. If you or I did it, it would be an assault. I mean, you'd have to be insane to say it's not assault. So to say it's justified, yeah, of course, because he has specific legal authority, as all police officers do, to perform assaults. That's one of the things they do with their time is, put people in handcuffs and, detain people. And I mean, things the police do on a regular basis: false imprisonment, kidnapping, battery, assault. This is just a short list of things that the police do on a regular basis. So but they have specific legal authority to do those things. Yeah. So they don't have liability for those things. So of course it's an assault. You'd be insane to argue it's not an assault. The issue is its justification. And I think the state has to concede. And I think they have conceded, although not explicitly, but they have conceded that it was justified at the start.
Yes, of course.
It wasn't unjustified from the very beginning. No. So their argument is somewhere along the line it became unjustified. And it's like, well, where along the line it becomes the trick, of course. And it's like, and also it goes to the intent. So he has the specific intent and justification that exists. And then it goes to like, where along the line does that stop being available, and also his ability to perceive it and his actual perception of it. So what was his actual perception and what was his ability to perceive can be argued, and both are influenced by the crowds and the situation and the dynamics and all the things I mentioned. So yeah, it's like, well, it was justified at the beginning and he couldn't possibly have informed the intent to go beyond the point, whatever that is, which the state can't even identify. Because of the dynamics, he couldn't possibly form the intent. So yeah, that's their best argument, is to argue against the intent. I still think they're kind of host on the manslaughter charge, though. To argue against the negligence is going to be tough.
Yeah, the culpable negligence. I
Yeah,
think
it's a tough
Scott-
one. I think Chauvin's
I-
kind of toast on the third. He's kind of toast on the manslaughter charge.
The manslaughter in second degree. I think most, if not all, people believe they got manslaughter in second degree.
Yeah.
I think the depraved indifference murder. I think that's a little harder. But
Yeah.
I also have to say, if you agree they got murder in the second, manslaughter in the second degree, you got to believe they got assault, because manslaughter in the second degree is harder to prove than the assault.
No, because you only
You
need
did
the
have an
culpable
additional
negligence
witness.
instead of intent. So the mens rea is lower.
Yeah, that's true. Good
Your Honor,
point.
the state of Minnesota rests.
Thank you.
That's
Yay.
it.
Nelson, are you ready to proceed?
The state
Call your
rests.
first witness.
I'm surprised he didn't do a motion to dismiss, saying the state didn't prove his case. So he probably just was like, "Hey, they obviously prove." I mean,
Maybe
you know,
he's gonna do it right now. I don't know.
maybe, yeah.
Your Honor, the defense calls Scott Creighton.
No, they're
Probably
going right
not.
to they're going right to their case in chief.
You didn't want to even do it just for the record as a formality.
Yeah, just hey, the state hasn't proved this case. They probably said, or they could have done it previously, because they knew they were arresting this morning. So right now the state is saying, so for everybody who doesn't understand, right now the state is saying that they've presented enough evidence where a reasonable jury can convict Derek Chauvin off the basis of what they have now.
Yeah, I think they're
And
right.
the defense has not put a motion to dismiss at this time. What they're doing is just going straight to their
Raise your
case.
right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Have a seat. I have to delay just a little bit. Having trouble getting the computer to work, and there's something I have to read the jury, but you can be seated. All right.
Now, would you have made the motion? I would have made the motion that the state didn't prove its case.
Of course I would. I mean, I know it's not going to work, but I have to for the record. Of course I would.
I was like, the state hasn't proved shit. Blah, 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 you know, dismiss these charges, and then let the judge smack me down. Of course, the state did it. Blah blah blah. Obviously, outside the purview of the jury, because you don't want the judge to say that in front of the jury. But
Yeah.
you know, obviously that's the motion. That's the motion I would have made. But maybe in Minnesota you can't make that motion now. You know, they don't have that procedure. But
That seems unlikely, but okay.
but I think I would have made that motion. They haven't proved their case beyond a reasonable doubt. Well, they haven't proved their case to send to a jury. So even if everything. Somebody says Secret Girl. I haven't really spent a lot of time with Nate. I usually follow Robert Gould. Oh, cool. Robert's been doing a good job. But you know what? It's interesting because the use of this case is really specific about the use of force and the use of force that officers are used, because this case is going to come down to this. Was Chauvin justified in using this amount of force? That's what this
Hold
case is
on.
coming down to.
Technical issues.
Nelson's been doing a hell of a job too. You got to give Nelson credit. He's been doing.
Yeah, the
really good
judge?
job. No, I'm talking about Nelson, the defense attorney.
He's been doing okay, but I thought you were pretty on point yesterday on your criticism of Cross. Like maybe, remember, like, keep control of the witnesses. Was
Yeah,
a pretty good point.
Control the witness, entertain the jury, respect the judge, and what do they call it? And manage the lawyers. Oh, maybe. We got somebody said the prosecution failed to prove their case. Well, if you
All right,
you know,
just
you
have
got
give your
you got to
first,
have reasonable doubt.
middle
Did
and last
they
name
fail to
and
prove an
spell each of
assault?
your names.
You got an assault. I'm
My
sorry.
name is Scott Robbie Creighton, Creighton.
Members
Spell
of the
both
jury,
of your names, you jackass.
you are about to hear evidence of an occurrence involving George Floyd on May 6th, 2019. This evidence is being admitted solely for the limited purpose of showing what effects the ingestion of opioids may or may not have had on the physical well-being of George Floyd. This evidence is not
Not
to be
propensity.
used as evidence of the character.
Yeah,
of
not
George
propensity
Floyd.
evidence.
Mr. Nelson.
So everybody understands what that
Mr.
means.
Creighton, by
You
whom are
can't-
you currently
We'll
employed?
talk about that in a second. I'll make a note, 'cause that's
Your
very
Honor,
important.
is there any way that you can, I could hear it a little louder? Could it be a little louder? I'm having a difficult hearing. Sorry about that, sir.
No problem.
I just want to make sure I hear all the questions.
So why the judge said that is because Just
that
because
better?
Floyd
Yes, it is.
did this for the
Okay.
past
By
doesn't
whom
mean
are
he
you
did it this
currently
time.
employed?
So that's what the judge is saying. You got to be careful.
Right now, I'm currently retired. I'm not employed by anybody.
Prior to your retirement, by whom were you employed?
The City of Minneapolis Police Department,
And how long did you work for the City of Minneapolis Police Department?
28 years.
Can you describe for the jury generally the various roles that you had for the Minneapolis Police Department?
Yes, I will.
That's correct. Barney's
I
correct.
started in 1993. I started on the street working as a 911 responder. I did 6 years as a 911 responder, and then I transferred over to public housing for approximately 9 months as public housing officer. And then from there, I went to the 4th Precinct and became a community response team member, involved as a street level narcotics investigator. I did that for 22 years.
All right. Now, were you on duty on May 6th of 2019?
Yes, I was.
If you had an opportunity to review various police reports and body-worn cameras from an incident on that date.
Yes, I have.
On that date at approximately just before 5:00 p.m., did you execute a traffic stop of a red Ford Explorer?
Yes, I did.
And did you approach the passenger side?
Yes, I did.
Can you describe just very briefly the initial interaction that you had with the passenger of that vehicle?
I approached the vehicle on the passenger side. The passenger window was down. I started giving the individual that was in the passenger seat commands several times. The passenger was unresponsive and non-compliant to my commands. I then had to physically reach in because I wanted to see his hands because I couldn't see his hands. I reached in finally and grabbed his hand to put it up on the dash, and then that individual was taken from the vehicle and handcuffed.
Okay. Did you make any observations as to the passenger's behavior?
Could you repeat that question, sir? I'm sorry.
Did you make any additional observations as to the passenger's behavior?
Yeah, in my mind, his behavior was very nervous, anxious.
I will withdraw that question. In terms of, did you see the passenger do anything physically with his hands?
Yes, he turned away from me towards the driver's seat as continually as I was giving him commands to see his hands.
Did you draw your service weapon?
Yes, I did.
These are a lot of leading
Did you,
questions. I would start.
Observe
Ken,
the
this is
passenger
direct.
put anything in his
Strictly
mouth?
speaking, it's not leading because it doesn't suggest the
Can
answer.
you say that one more time, sir? I'm sorry.
All right,
Did you
listen to me
observe
say.
the passenger put anything in his mouth?
No, I didn't.
Did you observe the passenger
Did
put
you,
anything in his mouth?
were you
That's a
wearing
leading
a
question. Yes,
body-worn
or yes.
camera?
Yeah,
No.
but the fact that it calls for yes or no doesn't make it leading.
Yes,
It doesn't suggest
And have
which
you
the
had an
answer is
opportunity
right.
to review
So it's not leading.
your body-worn camera
It is
prior
leading.
to
That's
today's
exactly.
testimony?
No, it's
All
not.
right,
I have.
the leading question is
Your Honor,
yes. That is a leading
No.
question.
upon the order, I
No.
will move to admit.
You,
and
you
publish
saw you
exhibit
saw him in just a tablet
1051.
correct would be leading.
Hold on. No. It's suggesting an answer.
1051
No.
is
Especially on
received,
direct.
subject to the motion of limit.
But you know what? I'll defer to you. All right.
If we may publish.
How are you doing? Can you undo your seatbelt, sir? Sir, passenger, can you undo your seatbelt?
Oh, and just so everybody knows, leading questions are allowed on direct for
Go
background
ahead. Oh,
stuff
yes,
like
that's
that.
true.
So it's not. So it's not like it's totally
I don't-
forbidden.
I don't
It is
plan on
allowed
shooting you. I'm
under
just
certain
saying, let's
circumstances. So.
Take your time. Okay,
Yeah,
relax.
didn't they have a
Undo your
motion
seatbelt.
eliminate
Better
that
take care of
leading
her,
is
guy.
okay all the time or
Just
something?
keep your hands up where I
Yeah.
can see them. Hey,
This is a good video.
let me. Keep your hands where I can fucking see them. Okay, put them up on the dash.
This is great for the
Put 'em
defense,
on
though.
the
This is
dash.
fantastic. If you're the
I'm not
defense,
gonna
or if
shoot
you're
you.
rooting for
Put
the
your hands
defense,
on
this
the
is what you
dash.
want to see. You want to
Put your
see
hands
this.
on the dash. The last time I'm going to tell you that. It's simple.
You know what the jury is going to be
He
thinking.
keeps moving
You
his
did this
hands
before.
around. He won't listen to what I have to say.
Ah, devastating. This is devastating.
On your head.
Top your head. Open your mouth. Spit out what you got. Spit out
Devastating.
what you got.
Devastating. Spit out what you got.
Spit it out. He's eating all
Don't you jerk away from me.
Put your hands behind your back.
Ah, this is
Boy,
great.
come on out.
The defense is
Put your
this video. Oh my God, devastating.
Okay, relax then. You're not going to get beat up or nothing. You just follow what we're asking.
Spit out your mouth. Follow the directions. What do you swallow? Ah,
I apologize, man. I apologize. Yeah.
are you seeing that? They sidebar. He's destroying our case. I'm sorry, that was too loud. Let me turn
In this
down.
video, is he going to start saying "I can't breathe"?
Yes, he's going to start saying, "I can't."
Oh God, that's just what I'm waiting for. I'm just waiting for that line.
Ah, sidebar. This is horrible.
I like how we had a whole argument about whether or not it's leading when it doesn't even matter because they're allowing leading questions. That's how geeky we are over here on Nate the Lawyer's channel. Just so you know.
That's horrible. That video is horrible. Oh my God, that video is horrible. This is how the defense starts bringing in lead reasonable doubt. So a lot of people.
I do like them starting with this video, though. I really like them starting with this video. Get that taste right in the juror's mouth. Get that right in their craw right away. Like they started with their video. Let's start with our video. That's really good defense tactics. I like that very much.
And even though, now think about this, even though the judge says you really can't use it to think that George Floyd did the same exact, or he did.
Oh, the jury's already forgotten that instruction. The jury's already forgotten that instruction. I guarantee you.
This is what George Floyd seems to do.
It happened 10 minutes ago and they forgot about it.
Oh yeah. Start with, and again, law students out there, start strong and strong.
Your volume's a little low, Nate, by the way. I can barely hear you in my ear.
Identify the
This is starting strong and ending
driver
strong. That's
of
what you're
the
talking about. Start
pursuing
strong and
passenger.
strong. That's exactly what this
Yes, I
is.
did.
And who
Starting
is that?
strong and ending strong.
Mr. Floyd.
Your Honor, based on the court's ruling, I have no further questions for this witness.
Cross-examination.
It's better now? I'm good?
No further questions for this witness.
Get in and get out. He's doing the right thing. You get in and you get out. What more does he need to get? Putting pills in his mouth, struggling.
Good morning, Officer Creighton.
That's it.
Good morning.
You testified that you were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, right?
That's correct. Yes.
And you had your gun drawn.
I was
when you
devastated.
approached Mr. Floyd. Isn't that right?
Yes, I pulled it. Yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man. I don't want to get shot," right?
Something like that. Yes.
You told him to undo his seatbelt, correct?
That's correct. Yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air.
Yes.
And then you told him to put his hands on the dash. Is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard.
This is cross-examination, people.
Correct?
Yes, no, yes, no,
Oh, yes.
yes, no. You see? Witness hasn't
And
said
then
anything
the
else
other
but yes
officer
or no.
with
Yes
you
or
on the
no.
other side of the
This is
vehicle
cross-examination.
told you To put your hands on your head, correct?
That's correct.
And then you put
That's
his
it.
hands on his head, right?
That's correct. Yes.
And there was one officer who said that they were going to tase him, right?
That's what I heard. Yes.
You see?
You
Nothing but
reacted
yes or
pretty
no.
loud,
The witness is a
correct?
prop.
Yes, I was. Yes.
Yes,
Escalated
yes.
Real quick.
Some profanity as well, correct?
Yes.
And you had your gun
Look.
drawn the whole time you were giving commands, right?
Yes or
Once I
no.
started ordering him and he refused to show me his hands, yes, I eventually it escalated where I pulled my gun. Yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes.
He was conscious.
Yes.
He didn't appear to be in medical distress to you when you were pulling out of the car. Is
Textbook
that right?
cross-examination.
He
This is
was
textbook.
talking to you. He was standing up. Is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct. Yes.
He was able to walk.
This is how you control a
Yes,
witness,
he was.
ladies and gentlemen.
To talk to you.
Yeah, I like this. I like this. Really
Yes.
short questions, one at a time. Easy.
Yes, no, yes, no, yes, no.
He could stand. Yes. He could talk. Yes. He put his hands up. Yes. He just one question. Easy.
No matter what side you guys like, this is the type of cross-examination Nelson should have been doing yesterday
Yeah.
to the expert. You
Just
don't say anything except yes, no. That's
You
it.
you walk it through. You walk it through like Hansel and Gretel with the breadcrumbs on the ground, one breadcrumb at a time, just one fact at a time. You know, you instructed him to take off his seatbelt. Yes, he took off his seatbelt. Yes,
Yes.
You instructed him to put up his hand. Make your
Yes.
hands visible. Yes, he put up his hands. Yeah, he did
But
this.
this-
I
but
love the
listen to-
cadence. I love the questions. I'm in love.
And listen to what Kirk is saying. Only facts you're hearing is from the attorney. You're hearing no facts from the witness. The attorney is testifying. The witness is the prop. It's textbook cross-examination, beautiful in it. But I still think the video is a slap in the face. This video hurts.
No, I'm not saying the video doesn't hurt. I'm just saying that this is what cross looks like, and I'm a little bit upset about the defense's cross because not so much on this.
Oh yeah, no. I was making that as a point because you're an attorney. I know you know this shit. It's the people who are watching us who don't know it. So that's why. Hey, if you guys enjoy this too, don't forget like, share, subscribe. You can hit us with a super chat if you got an urgent question that you definitely want us to answer. Other questions, if we see them, we'll catch them. But yeah, this is if you guys enjoying this, let us know. Going with the Hansel and Gretel analogy, Kurt, who was then bird coming through and destroys all the breadcrumbs. Kurt. That's what they call
I
redirect.
hate you all.
Thank you, Your Honor. Officer Creighton, you were describing that you got Mr. Floyd out of the car, correct?
Yes.
And he stood next to the car and you handcuffed him, correct?
Me and another officer had to physically handcuff him, yes.
And he didn't fall down, correct?
No, he didn't fall down.
Nothing further, Your Honor.
Any further?
This should be good.
Now she got in and got out. So
Officer Creighton, there was another officer on the driver's side dealing with the driver.
Yes, that's correct. Actually, two.
And that officer was speaking to or giving commands to the driver
That's correct.
simultaneous to the time that you were giving commands to Mr. Floyd.
That's correct.
Did you hear the officer say, "Spit it out"?
I may have, yes. You'd have to see the video, and if that's what the video shows, then that's what occurred.
Okay. I have no further questions.
Anything further?
great question to end on. Great
Yeah,
question to end on.
Yeah, I like that. It's very nice. I don't know if it was deliberate or not, but it was very good.
Officer
Yeah.
Creighton, you were just asking
Thanks for-
questions about what the other officers were doing. You were interacting with Mr. Floyd, correct?
Yes.
And while you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
Wait a minute. What was the question? Can you speak up a little louder, ma'am?
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
Asked and answered. Asked and
Yeah.
answered.
It
She
is
asked
asked
the
and
question
answered.
before, so you can't just ask it
You were
again.
asking questions about what the other officers were doing, correct?
That's correct.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop
Yes, it
dead
is.
while you were interacting with him, correct?
No.
Thank you. Nothing further.
Anything further? Thank you. You may step down.
Win for the defense. That's a big win for the defense.
I like how this entire witness took like 10 minutes.
Yeah. But this was textbook cross, textbook direct, and I love Nelson.
Thank
He
you,
got
Your
in,
Honor. Your Honor, at this
and
time,
got out.
the defense calls Michelle Mosing.
no BS, no nothing. Just put it in. There's your doubt. This is what he does all the time. Here's a video of him doing it before, putting pills in his mouth. I'm in. I'm out. Call it a day.
I don't know what the nature of the objection or the ruling was, but I was surprised he couldn't get anything more out of that witness with that video.
Yeah.
You can just stand right there for a second. Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth? Have a seat. And before you begin, if you could state your full name, spell each of your names, and then hold off Mr. Nelson. Just give your full name and spell each name.
First name is Michelle, Michelle. Last name is Mosing, Moseng.
And if you're comfortable taking off the mask, I pretty much leave it up to you, but if that would make it easier to hear you, that would be appreciated. Members of the jury, this again is regarding an incident or an occurrence involving George Floyd on May 6, 2019. As I told you before, this evidence is being admitted solely for the limited purpose of showing what effects the ingestion of opioids may or may not have had on the physical well-being of George Floyd. This evidence is not to be used as evidence of the character of George Floyd. Mr.
Again,
Nelson,
another
remain quiet.
reminder.
Thank you. Good
Yeah,
morning,
right.
ma'am. By whom are you currently employed?
I am retired.
Okay. Prior to your retirement, where were you employed?
I was a paramedic at Hennepin County Medical Center EMS.
How long were you a paramedic for Hennepin County?
Just under 34 years.
Okay. And can you describe the education that you had to become a paramedic?
I have a 2-year degree in emergency medical care and rescue from Mankato State. And then actually got an additional registered nursing.
So just a
graduated
rule
from
here.
St.
They
Mary's
essentially are
University
putting George
in
Floyd on
91.
trial the
Okay.
first time.
And so you
But
worked
through
as a
this
paramedic
evidence,
for
not
Hennepin
not
County for the
technically,
entirety
but
of
that's
your
exactly
career,
what
or
what,
did you have
what he's
other
doing. He's putting
employment?
George on Floyd for
I
the
actually
over
worked
for
for a
the
year
pills
in
thing that the
Dakota
first
County,
thing, which is great, which is fantastic. If you
for
can get
1
in for the
year, and
defense,
then I,
he's doing the
have
right
worked
job.
at
This is what you
Hennepin,
want your
worked at
defense
Hennepin
attorney
ever since.
to do.
Fair to say you've gone to a large number of calls during the course of your career.
Yes.
And you may not remember every specific detail about every call, correct?
No.
And
That's a
as
fact.
a paramedic, do you
Facts.
maintain records about each call that you go to in order to assess the patient's care?
Yes, we do a run sheet or a patient medical record that we hand off at the emergency room.
Now,
If you can just speak up just a little bit.
Sorry.
No problem. Don't worry about it.
prior to your testimony today, have you had an opportunity to review a run sheet from May 6th of 2019 involving George Perry Floyd?
Yes.
Do you recall all of those details off the top of your head now?
No.
All right. Now, in terms of your recollection of May 6th of 2019, were you summoned to the Minneapolis Police Department
Yes, precinct 4.
to care for, to attend to Mr. Floyd?
Yes.
Upon arriving at the 4th precinct, did you talk to Mr. Floyd?
Yes.
Did you learn information from Mr. Floyd about what he had consumed and the time frame he had consumed it in?
Yeah, it was quite hard to assess him. He was upset and confused. Some of the things he said were.
I'm going to strike the answers non-responsive. If you could perhaps leave.
Certainly. Did Mr. Floyd, were you able to learn that Mr. Floyd had consumed some narcotics that day?
Yes.
What did he tell you specifically about what narcotics he had taken and when he had taken them?
He told me that he had been taking multiple, like every 20 minutes. And it was a, I don't remember if it was Oxy or Percocet, but it was a opioid based.
Would it be helpful to refer to your previous sheet?
With his behavior.
Of course.
At that point was real.
I'd like to
Refresh
read
your
the sheet at the
recollection.
time Now would be great.
I'm gonna,
The last statement about agitation is stricken as non-responsive. You can just wait for the next question.
thank you.
Thank you.
But he had informed you he had taken some sort of an opioid every 20 minutes or something like that, correct?
And then another one as the officer came up.
Okay, so he told you that he had taken a pill at the time the officers were apprehending him.
Correct.
Did you do a physical assessment of Mr. Floyd at that time?
Yes.
Specifically, did you take his blood pressure?
Yes, I took a set of vitals.
Would you agree that your first vitals were taken at approximately 1:34.
That's a
and
leading
55
question.
seconds.
Without looking at the run sheet, I wouldn't know for sure.
Would it refresh your recollection to review the run sheet?
Yes.
Yeah,
May
but
I
it's
approach the witness room?
it's leading foundational though, so I wouldn't object to that either. But you're right though. You're right.
Thank you. You've written on here that, yeah, it was 1334 was the first recorded vital signs.
That refreshes your recollection?
Yes. Did you need it back?
Yeah, I'm not sure. I'm not sure. It's not as clean as the prosecution, but maybe he just didn't have
If you need
time.
to refresh your memory with that, just let us know and we'll allow you to refresh your memory. But otherwise, testify to your memory as best you can.
Okay.
At approximately 13:34, that's 1:34 p.m., agreed? You took his vitals, correct?
Correct.
And that would include his blood pressure at the time?
Yes.
And did you record what his blood pressure was at that time?
Yes, it was 216 over 160.
That's a
Did
big
you
number.
ultimately make
Huge number,
recommendations
huge.
To transport Mr. Floyd to the hospital?
Based on that and other issues.
Okay. And ultimately, was he brought to the hospital?
Eventually.
I believe that's all I have, Your Honor.
Popping pills every 20 minutes and just went to the hospital and didn't die versus
With a blood pressure, what did she say? 216?
yeah, it was like super high.
Did she say 216 or 260?
I don't even know what she said, but I know it was high. 216 over 160. Yeah.
Good morning, Ms. Mosang.
Good morning.
You provided treatment to George Floyd on May 6, 2019, correct?
Correct.
Is that
Yes.
right? And you were concerned about his blood pressure at that time, correct?
That was one of the things.
And in the course of your treatment of him, he explained that his high blood pressure wasn't something new, right?
Initially, he denied medical issues, but then when I discovered his blood pressure, I specifically asked again. And he said, yes, he had history of hypertension and had not been taking his medication.
Lying
He
to
said
the
he had been
police.
taking his blood pressure
Lying
medication
to
for months,
officials.
correct?
Correct.
And he told you that he swallowed some pills, right?
Yes.
Approximately 7 Percocet, correct?
Refreshing recollection.
Documented, yeah, 7 to 9 every 20 minutes or so for a while.
And
7 to
Percocet's a
9
brand name,
Percocet every
right?
20 minutes.
Surely not.
Is that oxycodone and acetaminophen?
Yes.
And it's used to treat pain, correct?
Correct.
You testified that it's an opioid, yes?
Correct.
So he told you that he had been taking those pills throughout the day, right?
Yes, and I asked him why. He said he's because he was addicted.
He told you he was addicted and he responded to your questions about taking the pills, correct?
Correct.
And he was able to walk, correct?
Yes.
He was able to stand up.
Correct.
And you wanted him to go to the hospital, right?
Correct.
And he didn't feel like he wanted to go to the hospital, correct? He was resistant to going to the hospital, right?
I know he was real resistant to get on our bed. It was hard to tell exactly what he was upset about.
I'm going to object at this point.
I'm
Your
sorry.
Honor. Just with respect to going to the hospital, Your Honor.
Yes.
I'm going to limit your question, the question I asked to that. He didn't want to go to the hospital, right?
I'll say yes.
It took some time to convince him to go to the hospital,
Yes.
correct? And you indicated that he told you he had been addicted to opioids, correct?
Correct.
And he had been addicted to opioids at that point for a year and a half, right?
I am not aware of that.
But he didn't feel like he needed to go to the hospital.
He didn't want to go with us at that point.
I say objection. Asked and
You
answered.
were referred to your run report, right? The record that you keep.
I'm not sure who that
treatment
helps.
of patients. You see that up there, correct?
Yes.
And according to your run report, you documented that Mr. Wood was alert, correct?
Yes.
And that he obeyed commands, correct?
Eventually.
That's what's in your report, right? Correct?
Correct.
And that he had an
Yeah.
appropriate response to stimulation.
Correct.
Yes.
Correct.
He wasn't nauseous or vomiting when you were treating him, right?
No.
His respiratory rate was normal.
This is
No,
great.
it was
She's breaking
elevated
down.
at times.
You wrote respiratory effort normal in your report, correct?
At the beginning.
She's
yes. His
killing.
effort
She's
was
killing
normal.
it.
was
She's killing it.
increased at times.
And throughout your documentation, you wrote respiratory effort normal, correct?
Correct.
At 1334, at 1409, at
Wow.
1426. All those notes, you indicated that his respiratory effort was normal, correct?
Correct.
You know, now
He was not in respiratory distress.
she's
correct?
trying to prove high
His
tolerance.
blood oxygen
Extremely
level
high
was
tolerance.
normal, right?
Correct.
His pulse was normal, correct?
See, high tolerance, 7 pills.
Yes.
Pulse
His
normal.
heart rhythm was regular or normal.
Heart
right?
regular.
Correct.
Blood
His
pressure.
EKG was normal.
Correct.
EKG normal.
He had a
7 to
normal
10
rhythm,
pills.
Sinus rhythm, which is the rhythm of a normal, healthy heart, correct?
Correct.
And you indicated that you had been worried about high blood pressure for the possibility of a stroke, right?
Among other things, yes.
But he didn't
Yeah,
have
I
a
would
stroke,
be.
right?
Didn't have any indications that we were picking up at the time.
He didn't have a stroke while you were with him.
No.
He was never given Narcan, correct?
Correct.
No
He
Narcan.
didn't stop breathing.
No.
His heart didn't stop.
No.
He didn't go into cardiac arrest.
This cross has just
He didn't go
destroyed
into a
this.
coma.
No.
And you took him to the hospital, correct?
Correct.
And he was monitored for 2 hours and released right after, right?
I don't know.
That's
Mm.
right, Your Honor.
You don't need an answer. You don't need an
He
answer.
stepped down.
That was disastrous right there. That cross, that's how you cross. That's how you take a bad witness.
She was good
And
on her
cool.
tone. I liked her tone. I like her pacing. I love this girl. She's great.
That was a cross to death because it was just like, hey, all right, he took you said he took 7 to 8 pills every 20 minutes. Okay, so he didn't overdose, right?
That's what she said, but I assume she doesn't mean that. I assume what she meant is she took 7 to 9 pills every 20 minutes.
No, I'm
Because if
assuming
he
that
took 7 pills every 20 minutes,
I think he would have been dead.
yeah.
But
So that's what she said, but I don't think that's what she meant.
But even though, let's even give the benefit of the doubt. This guy took 7 to 8 pills. We're talking about 2 pills. This guy's taking 8, and then swallowed 2 when the cops came, and was still blood pressure. Again, what that showed, what that defense course was all about, was this man had an extremely high tolerance to
All right, jury,
opioids.
we're going to
That's
take
what that
a
was.
lawyerly 5-minute break, which means it'll probably be 10. But let's go with 5 minutes for now. Thank you.
Well, so far so good for the prosecution. They weren't able to do as much with these witnesses. I'm surprised they weren't able to do more with that video. I wish they'd
This because it
done
was
more
limited.
with
It was in for limited, and you don't want it, and you can't bring it in for propensity. But I will say this: the cross today are excellent. The cross examinations today are excellent, textbook crosses, and I think Nelson is doing exactly what he needs to do. He doesn't need to prove anything. He just needs to show doubt, and I think that video shows the doubt. I think it gives you a little doubt. What do you think?
Yeah, well, I think the defense has done pretty good in trying to establish doubt throughout. The prosecution certainly held their own, and better than that, in trying to rebuff that doubt. But I think the defense has done great too. I'm a little bit disappointed with the defense so far, but we've only been at this like an hour or something.
Yeah,
Well, less than that really. So we got 2 witnesses apparently done already, and not so much. So I also took note internally that both the people they called were retired. Which I don't know. Like, well, we couldn't find it. Would be, can we find anyone who's currently on active duty with the Minneapolis Police Department who wants to testify for the defense? How's that blue wall silence work when the entire police department turns against you? Can you still find an officer who's be like, actually, as it turns out, I disagree with the chief of police, and I disagree with the head instructor, and I disagree with this. I think it's totally fine. Will they find anyone who's on active duty? Find out.
Yeah, when everybody says that. I think at this point in time, no. Again, because I think most people don't know what reasonable doubt is. So let me put the standard up here so people just know what it is. The reasonable doubt standard in Minnesota, somebody tweeted it to me. Let me see if I can just pull it up. I actually wrote it here. Where's it at? Let me just Google it again. So people understand what reasonable doubt is. Just not I have any doubt, right? It's very specific in law.
Yes.
So I want to bring up because and then each state kind of has like little different variations to it.
It's basically the same at the end of the day.
But it's basically the same during the end of the day. Hold on. Oh. Metro Court. I'm just going to go to the court's website. Reasonable doubt are. All right, so people can see what I'm doing instead of me just trying to hide it from you guys. Take that off screen, put this up. We are going to look at the Minnesota court's reasonable doubt. So we all know what we're talking about when we're trying to evaluate this. Okay, guys. Here it is. These are the judicial terms, the terms from the court. And I'm going to R to see if they have reasonable doubt here. Relevant, reasonable doubt. No, they don't have it here. Oh, here it is. Beyond a reasonable doubt. Boop. So a standard of proof required to convict a person. A jury has a high degree of certainty that the defendant's guilt, although they need not be 100% convicted. So this is actually not the full legal standard. Let me see.
That's not a really good definition.
Yeah, it's just
I could paraphrase the legal definition off the top of my head, but I can't give it verbatim.
No, I have it here. Let me just. I just got to pull up another site because I actually have it written down. Let me see if I can just find the legal definition. So this morning,
if you want the non-legal definition, somewhere between 95 and 99% certainty. That's the non-legal definition.
What am I? Let me try to go to Google again. This is one thing I hate about
somewhere in that ballpark.
Only reason why I want to make sure I just read it out to people, everybody understands what we're looking for. All right, so here's a lawyer's website from Minnesota, and I think this is probably the best understanding of it. So you guys should be able to see this and understand this before the court gets back. The court's not back yet, right? No.
Nah, they're leisurely, lawyerly. 10 minutes.
Let me share
5
this.
minutes, whatever.
All right. Term. Here it is. All right. So this is from another lawyer's website. Reasonable doubt. And this is what we're looking at. Commonly in Minnesota courts, beyond a reasonable doubt is defined as such proof as an ordinary prudent man and woman would act upon in their most important affairs. So if if you're sick and a doctor gives, like you got 5 doctors that say one thing, and you say, I don't believe all 5 doctors. That's not reasonable doubt, right? Because it's if the most important things in your life, the most important affairs, if you would rely on that, then that, what I'm saying, that it would be, if it's reasonable for you to rely on then it's reasonable for you to rely on now. Reasonable doubt is doubt based on reason and common sense. It does not mean fancifully or capricious doubt, nor does it mean beyond possibility of all doubt. So this is the standard that they're going to tell the jury that they need to use to come to it. So that's why when we were talking about the other day, I was telling people, I was like, is it reasonable to believe all these experts? Is it reasonable to believe this? Is it reasonable? Because that's the standard. If I got 10 doctors saying the same thing and you say, well, I don't believe them. That's not reasonable doubt, right? That's not reasonable. And that's what you're talking. That's what you're looking at. Is it reasonable?
The one that I always heard in law school, the one that always made me think twice, was that beyond a reasonable doubt is the level of confidence you need in order to get married. Like how sure do you have to be in order to marry someone? Because presumably the decision to get married to someone would fall into the category of life's most important affairs, right? The most important things that you said. So how sure do you have to be? Which sounds really good, right? Up until the time you consider what's the divorce rate again? And so beyond a reasonable doubt apparently means that we're wrong, 30% of the time or something. So I don't know, man, if that's good or not. So yeah, apparently beyond a reasonable doubt being 70% sure or something. I don't know. Yeah.
But again, if you had a serious illness and all the doctors said this is the stuff you use, is it reasonable to not believe them? That's kind of what you're looking at. Any chance that the defense let the heart doctor go yesterday because of the sense of joy finding him condescending? Possibly, but I don't think anybody would watch that cross-examination and think Nelson did a good job. Nelson, he could have done better, but it is what it is. Doubt as to what? Doubt relevant to the charge. Whether the
doubt as to any element of the charge, to be very
Yes.
precise about this. The state has to
Yes.
prove each and every element of the charge beyond a reasonable doubt.
a reasonable doubt.
The defense only needs to show a reasonable doubt as to one element of the charge, and that's sufficient.
So essentially,
very fancy.
the prosecution has to win on everything. They have to prove A, B, C, D, all beyond a reasonable doubt. The defense has to just stop one. They just have to. If you don't have intent for assault, done. You don't. He was justified. Done. They just have to win on one. The prosecution has to win on all 10. So that's what we're talking about. So right now, as to the assault, like I don't think there's reasonable doubt as to the assault. I think you can start getting something into manslaughter. Maybe you can get something to, but as to the assault, I just don't think you have reasonable doubt to the assault. And I think that's where this big is going to come down to. Because again, they don't have to prove he intended to kill him. They just have to prove that you have an intentional assault. That's so much of a lower standard. But we will see. We will see. Let me see. There's some questions in the chat. Nate the lawyer, 4 out of 5 say something is, aka 20% don't. Hey, that's why reasonable, but nobody's polling the jury and saying, hey, what is this your reasonable doubt? Like if all the jurors say not guilty, then nobody's going to say, oh, well, but it's just the way they should be looking at it. And again, it's an oath thing. You should be looking at it this way, because again, if you were on trial, hopefully the jurors would look at it the same way as every other juror, so you can get, so you can get a fair trial. Because without that, you may not get a fair trial. Here it is. Nate the lawyer, my hubs and are both in the medical field. He could take 9 pills every 20 minutes. That is possible with tremendously high tolerance. For you and I, it would kill us, but not him. And that's and you see, that's what I think. They got an effect of him, the popping pills when you get arrested. That's it, right? You can't avoid that. But now you can't avoid the fact that he's got this super high tolerance. This guy's popping them like Skittles. He's M&Ms. He's throwing them in his mouth. He's going to throw 2 down right now. 20 minutes later, I got to take another pill. This guy's living off these pills. For me, 1 pill, I'm probably going to have a heart attack. For him, he's taking a pill every 20 minutes. That's high tolerance. So even if he took 2, less than likely he's going to die. Does that make sense? I'm civil.
Works for me, yeah.
But again, this is the back and forth. Thanks, Lisa. Thanks for that. But so what do people feel? Barry on, Nate the lawyer. If Chauvin says he was holding Floyd to aid him from excited delirium instead of restraint, would that remove the assault angle? Possibly, but let's not forget the use of force has to be reasonable throughout the entire event. So at any point, so when Floyd becomes unresponsive, not moving, someone checked his pulse and said I don't feel a pulse. Someone holds him down and says, hey, maybe we should roll him over. Is it reasonable all the way through? It might have been reasonable when he was struggling. It might have been reasonable while he was still awake. But when he became unresponsive, no pulse, no breathing, that's not reasonable. That's what I'm saying. And let's talk about excited delirium. Let's not forget the prosecution did put on an expert who checked off all the boxes and said, this, my expert opinion, is not excited delirium. So you still have to overcome that too. You said 2019 video adds doubt. I said, yes, it adds doubt. It does add doubt. It adds doubt to whether Floyd was, whether this is something Floyd does all the time, because don't forget the defense is trying to add the fact that he had an overdose, right? So that's the doubt they're trying to add. I'm not saying it's beyond a reasonable doubt, but it adds some level of doubt. I don't think you can watch that video and not come to that conclusion. My question is, what doubt would be as relevant to the charge? I wasn't talking about, well, we're talking about doubt in the sense of to the charge, because don't forget, they have to prove that Chauvin was justified in doing what he did, right? Or there was some other reason. So that's where I think the doubt is. They're saying that Floyd does this all the time. And they're saying Chauvin is just another police officer who had to deal with this. So this, he does, no hands, no this, popping pills. I don't want to be arrested, And then the second time with Chauvin, the same exact thing. So that's what they're trying to show, a pattern of conduct, even though it's not supposed to be used for that. That's what they're trying to show. I hope that answers your question, Barney. Any more questions? They're definitely taking this hour break. Here's another one. Nate the lawyer. Can you take a handful of pills?
To quote my cousin Vinny, are you sure about those 5 minutes?
Ooh, Nate the lawyer. You can't take a handful of pills over and over. Drug addicts don't live forever. But this one does. This one was taking one every 20 minutes, right? That's what they all said. He admitted, I've been taking them every 20 minutes. I just took a fistful of them, went to the hospital, and was gone in 2 hours, right? He didn't OD. Why? Because his tolerance was high.
And I had a damn heart of 260. Top number. I know I'm not a medical expert, but I do think that qualifies as hypertension.
It is hypertension, but goddamn, this guy, as you know,
he's Lemmy or Ozzy Osbourne. I mean,
because for me, I question Chauvin's training. Was Chauvin trained in the restraint? No, he wasn't trained with the leg restraint in this way. Was he trained when to stop? Yes, all officers are trained when to stop. You're supposed to de-escalate. When someone is handcuffed, number one, you're supposed to de-escalate. But even if he's struggling, he struggles, but to a point where he became unresponsive. That's when the de-escalation. All this is great, right? To show, hey, we did this. I would even give the police officers, Chauvin and this group, I would say, and even the prosecution's witnesses even agree that he was resisting and some force was necessary to get him under control. That's no doubt about that. I think everybody's going to agree with that. But when he became unresponsive, right? When he started struggling, when he became unresponsive, that's when you turn it from justified use of force to now you're starting to turn it into unjustified. And then, he's 4 minutes there sitting there lifeless and you keep, then obviously that's too long. And that's what the state's going to harp on. The state, don't forget, and I think this is something the defense has to realize. I don't think the first part of this incident is the problem. I think the part when he's on his neck for the 4 minutes unresponsive, and the other officer checks his pulse and says he has no pulse, and the other officer says maybe we should turn him around. That's the damning part. That part, Chauvin, I think it's going to be hard for Chauvin and the defense to overcome. I just do. What do you think, Kurt?
Yeah, I mean, the defense has the work cut out for him, but they're getting a reasonable start going so far. So,
Oh yeah.
I mean, but it could be better. I mean, I wish we had gotten more from these witnesses than we did. I felt like there could have been done. We could have done more with them, but I'll give him. We'll see how it goes, I guess.
Well, one thing, I would have started with the video if I was Nelson too. Why? Because I think starting with the video will let you do one huge thing, right? Shock and awe. Oh my God, Judge, because I don't believe probably most of those jurors, just like most of you guys, probably never saw that 2019 video. And seeing it for the first time is shocking. You know what I mean?
I'm sorry.
No, I said seeing that video for the first time is shocking. I don't think the jurors saw that video for the first time. Yeah, we just read that.
Yeah.
So it just is. Seeing that video for the first time has an effect. And the jurors sitting there seeing that video for the first time, the first thing I thought when I saw the video was, oh my God, this is what he does all the time. If that's not what you guys thought in the chat, I'm sorry. I don't care if you think Floyd is, I don't think Chauvin is guilty or innocent. When you first see that video, your first thing that comes to your mind is, this is what he does when he gets arrested. Is that what you got, Kurt?
Yeah, I mean, that's certainly the purpose for which it's being offered for, that his resisting is normal behavior, that his failure to follow instructions is normal behavior, that his chewing on pills apparently as he's being pulled over is normal behavior. This is something he just does all the time. He's like, I'm being pulled over. Now, some people might pop mints. What he does is pop pills, which is a strategy I hadn't thought of up until now. And maybe next time I'm pulled over for that DUI life, maybe instead of the mints to try to cover my breath, maybe next time, how about the fentanyl? I did not think about that plan. I'm not sure I recommend it, but apparently it's an option. So yeah, this is kind of normal behavior, and his inability and his resisting and his, failure to comprehend English apparently are par normal. So yep.
But he was resisting the first time. They didn't put him in a prone position. He didn't die of an overdose, right? And those are the two things that the defense now has to kind of walk around, because that's what the prosecution in their rebuttal was essentially saying that. Well, he didn't. He survived, right?
You know what the real sin is? That he didn't offer to share with the officers. It's like, I have some. You know,
Right,
I
we're on the
I
record
brought
now,
enough to share with the
trying to get into the
class,
jury.
which you like some. He didn't even make the offer, man.
Nah, he did. He did. Here we go. What's up with the birds chirping? It sounds like birds are chirping. Is that you? You got
That's
birds
outside
chirping
my
back there?
house. Yeah, that's outside my
Oh.
window, man.
I'm like,
The birds
what
are
birds do they got inside the courtroom here?
No, it's birds outside my window who are trying to cheer me up, man, to remind me that life exists.
Hey, man, come on up.
Sounds nice.
I don't think it's reasonable.
You can just
Not
have
when
a
you got
seat for
all
now.
these experts saying that it's not. All these
To
experts
testify,
showing
I
it's
place you
not.
under oath,
Sorry.
but otherwise, we're just going to have a discussion a little bit here. So, but we do need to hear you so that the court reporter can take everything down. So, you have been subpoenaed by the defense.
I can't even really.
Let me do that. You've been subpoenaed by the defense to answer certain questions about being with George Floyd on May 25th, 2020. What you observed about his physical condition at various points in Cup Foods, and basically a time frame on when you were with him that day and what you observed about him. Specifically, I think focusing mostly on the time in Cup Foods, but then also in the motor vehicle before the police came to the window.
Yep.
Okay. And you're willing to answer those questions
Yes.
about George
Yes.
Floyd? Okay. The parties also have the right to ask you, in order to test whether your perceptions are accurate, on whether you were under the influence of drugs or alcohol that day. Are you willing to answer that question?
Yes.
Okay.
Am I or him?
Are you willing to answer the question
Well,
whether you were under the
Oh,
influence of
yes.
drugs or alcohol?
yes, I was not.
Okay. We're not going to be eliciting an opinion from you whether George Floyd was under the influence, just for how he looked.
Okay.
And how he acted.
Yep.
But not an opinion about whether he was under the influence.
Okay.
But the lawyers, in order to make sure that the jury knows whether to consider your evidence and how much weight to give it, is whether you were sober or under the influence. Are you willing to answer that question?
Yes.
Okay. Now you understand.
If I was,
I don't
well,
find that those questions
if she wasn't,
expose you to criminal liability, but you do have a Fifth Amendment right
now,
not to incriminate yourself.
if
You
I
need
was
time
her
to talk to a
attorney,
lawyer, and I have limited the lawyers
Waiver.
to those topics so as not to get anything that might tend to incriminate you. that you
never
want.
waive anybody.
Okay.
Never waive nothing.
Do you have
You
any
never know what questions.
Do you need time to talk to a lawyer? Okay, ready to go then?
She just wants
Is
to
it pretty
go.
typical in
What
your
we're gonna do
experience
is
where
we're gonna bring the
where they
jury
do
back
this?
And then I'm gonna
Where the
have
judge
you
does
sit
it
so I can swear
to
you
a
in,
subpoenaed witness
and then
like
we'll
this?
go from there. Do you have any questions?
Well,
Typical in your
she,
experience?
Okay, great.
yeah, the judge
Okay,
talks to the
jury.
witness before, but this witness can. The thing is, this witness does have a Fifth Amendment right against self-incrimination. So he's just going over all that. You know what I'm saying? You don't have a right to testify. The defense is that subpoenaed you, but she wants to talk, so and she wants to waive it. In other words, she's saying I didn't do anything wrong, so I'm here.
Oh, you want to stand up?
You can stay seated.
Oh.
I'll ask you to stand to be sworn, but just follow my directions. You'll be fine.
So they asked all that outside the purview of the jury. So the jury didn't hear any of that exchange. They're coming in now, and we're going to hear this. And we're going to hear them talk now. The jury's going to hear her testimony now, which is limited to her observations of George Floyd. I mean, her observations. Just so we're clear, this is a person who I believe this is a woman who was in the car with George Floyd at the time of the incident when he first got pulled out.
Okay, Mr. Nelson, you may call your next witness.
Your Honor, the defense calls Shawanda Hill.
Ms. Hill, if you could stand right in the witness chair, or actually, there's fine. You could raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
Yes.
All right, have a seat, please.
Here it is.
Gloves.
And before we begin, we're going to have you state your full name, spelling each of your names.
Shawanda, Shawanda, Renee, Renee, Hill, Hill.
Mr. Nelson?
Thank you. Good morning, Ms. Hill.
Hi.
Thank you for being here with us
I think
today.
she's under the influence right
I
now.
just have a few questions
I
about
don't
May
know.
25th of 2020.
Let's
Do
see.
you recall that date?
Yes.
On that date, were you at the Cup Foods located in Minneapolis?
Yes. Yes.
Did you run into anybody that you knew while you were there?
Yes. George Floyd.
And while you were at the Cup Foods or in the Cup Foods, did you have an opportunity to observe Mr. Floyd's behavior, demeanor, things of that nature?
Yes.
How would you describe Mr. Floyd's behavior while inside of the Cup Foods?
Happy, normal, talking, alert.
Okay. Did he offer to give you a ride?
Yes.
A ride to wherever it was
My
you were
house.
going? And so did you go to his car with him?
Yes.
Once you got into the car, did you observe any changes to his demeanor?
When we were in the car for the first like 8 minutes, we were talking and, you know what I'm saying, hugging, you know what I'm saying, talking about what we were about to do. And
Go to the
then
house
I
and
got
get
a
it
phone
in.
call. And so I was on the phone for the rest of the time until the little boys came to the car. He fell asleep at that time.
So at some point during the course of the time that you were in the car with Mr. Floyd suddenly fell asleep,
Yes.
right? And the phone call you received, was that from your daughter?
Yes.
And so you were talking with your daughter during that time?
Yes.
And you described, would you agree that at some point, you said some little boys, are those employees of the
Yes.
store?
Sorry, yes.
That's okay. The store employees came and approached the car, correct?
Yes.
And at that point, Mr. Floyd suddenly fell asleep.
He was already asleep.
He was already.
No, she doesn't
Yes.
seem like she's under
When he
any
came to the
influence or
car.
anything like that.
Okay,
It's
fair
just-
enough.
that's
And when they
just
came there,
just
tried to
her.
wake him up. They
That's
tried
just
to
her
wake
her
him up,
demeanor.
tried to wake him up over
She
and
seems
over.
fine.
And his friend tried to wake him up, and he woke up. Then he'll say something. He made a little gesture.
No, this is
you
not
know,
the
and-
dealer. This is
Not
the
in
woman
my
he
car.
met in the store who she was giving the
Was
ride
He
that-
did
to.
that a couple times.
Was
She
that
had-
kind of a sudden change from
She
how
has,
you observed him?
from
in
right
the
now,
store
she has
to the
nothing to
car?
do with the
Yes,
drugs
but
or
he
anything
already
like
told
that.
me in the store he was tired because he had been
I'm
working.
going to
all
object. There is an objection.
Leading, yes, the answer is stricken.
Overruled.
And so at some point, did the store clerks leave the side of the car?
Yes, I told him that I would wake him up and send him in there because I didn't have the money on me. I used my money. So.
Okay. And did you continue to try to rouse
Yes.
Mr. Floyd?
We finish the questions so that we don't overlap, okay? Because the court report is taking everything down, it's really hard.
The overlap.
Okay.
Okay, thanks.
Thank you. So did you continue to try to awaken Mr. Floyd?
Yes, I tried a couple times, but then, you know, I just let it go for a minute because I was back on the phone and
All right.
you want to hear the rest of it.
And did the store clerks come back to the car
If
a
the
second
court
time?
stenographer could get that last part down. She's,
And were you, at some
What?
point, the police officers approached the car
Yes,
and Mr. Floyd was aroused by the police?
yes.
I have no further questions, Your Honor.
Mr. Grant.
Yeah, she's
Really?
fine.
really, like, you didn't see him. Maybe, like, did you see him ingest anything while in the car? Were there pills in the car? Nothing like that. No.
Good morning, Ms.
That-
Hill.
that's
I just have a
incriminating,
couple follow-up
Because don't forget, your
questions
pills in the
for you,
car
okay?
that could implicate them all. So
Um,
they're trying to
so
stay away from those
During
things.
the period that you were with Mr. Floyd in the store, he was, you said he was alert,
Yes,
friendly,
yes.
talkative,
Happy talking, yes.
and
Back, hugging.
and when you went out to the store, he walked by himself out to the store.
Yes,
In fact, did a little dance as he went out to the car.
yes.
You're just like, we're going
We
back
just
to
have
the
make sure
crib,
that you wait till the
dancing.
Questions done, so we aren't talking over each other. Okay. I know it's a hard habit to break, but we just have to be careful with that,
Jesus.
okay? And when you got back to the car, at some point he nodded off,
Yes,
Yeah, not at all.
but you were able to wake him, correct?
yes,
And talk to him.
yes. but he wasn't that coherent at the time.
He was just awakening
Yes,
and nodded off again.
yes.
And at some point, the police officers walked up, correct?
Yes,
Yes.
no,
Yes.
that's it. She's just saying
And,
yes.
And then he, well, you woke him up when the police officers walked up, correct?
Yes.
And so then he was awake.
Yes. You just want to say yes or no, explain what do you want me to do?
Well,
I
explain.
want to explain. Okay, thank you.
She was like, you don't want me to say yes or
When I tried to
no?
wake him up, he woke up the second time. I said, Floyd, the police is here. It's about the $20 bill wasn't real. I kept saying, baby, get up. The police was out. So he looked, and we looked to the right, and he had the police. He tapped on the window with a flashlight. And I'm like, Floyd. And so he turned back around again. He's like, what? And I was like, baby, that's the police. Open the door, roll down the window, whatever he told me to do. So he looked back, and when he seen the man had the gun at the window when we looked back to him. So he instantly grabbed the wheel, and he was like, please don't kill me. Please don't shoot me. Don't shoot me. What did I do? Just tell me what I did. Please don't kill me. Please don't shoot me. And I'm like, Floyd, baby, it's not. You said explain. I'm trying to explain what state he was in, sir.
That's why you don't let the witness.
You said to explain. Yes, please did.
Look at her. She's like, oh my God, you told me to explain this shit. Now you ain't let me explain it.
Where were you sitting in the vehicle?
Don't let the witness give a speech.
I sense a redirect
And
coming.
so when officers came, were there two officers that came to the vehicle?
Yes.
So one came to the passenger side and one to the driver's side?
Yes.
So initially you saw one officer to your right on the passenger side, correct?
No, I was up like I'm trying to wake him up. So I'm in the middle, like at the time, when the police were there. That's how I was able to see him too. Just we both looked at the same time.
This is why you don't want to witnesses start talking. Yes or no? You want to get it back to yes or no? Yes or no? Yes or no?
During this time period, coming out from Cup Foods and being in the vehicle, did he complain of shortness of breath at all?
No.
Did he complain of chest pains at all?
No.
And other than being sleepy or nodding off a little bit, did he seem abnormal to you?
Let's not be racist here.
And
just because a black woman from the hood
when
has a little sass doesn't mean she's a drug addict.
pulled a gun on?
Let's be honest here. Come
I
on,
have
guys.
nothing further.
Thank you. While you were in the car, or prior to getting in the car, Mr. Floyd appeared to you to be normal, correct?
Yes.
When he got in the car, he fell asleep, correct?
We talked for a while, then he fell asleep.
And then ultimately, you had to make several efforts to try to wake him up.
Yes.
I'm looking for.
Thank you, Ms. Hill. We appreciate you coming in. You are excused.
Thank
you. Yeah. Yeah, just Miss Hill.
Right out the door.
She goes right out the door. So this witness was just to get Floyd's state of mind. He was lurpy. He was sleepy. He could hard to wake him up. They're trying to get that in his state of mind. There is no evidence that this woman is. And again, I don't think anybody can say this woman's a drug addict or have anything to do with the drug game. Why? Because the defense called this witness. She could have easily, if she had drugs or she was using drugs, she could have easily said, "I'm not testifying on my Fifth Amendment right." This woman's coming, says she has nothing to hide, and asked these questions. So this is the other officer, Peter Chang. This is the other officer, right? Who is this? Oh, this is the other guy in the car. Huh.
I thought the other guy in the car was pleading the Fifth. How many people were in this car? What is it, 3?
I'm not even sure. Yeah, but that's not this. This is a woman that he met in the store and was giving her a ride home. So this was somebody he was trying to get with in the moment, right? this last witness, no one has even alleged that she sold him anything. Maybe his drug dealer was in the car, but this woman was somebody he was giving a ride home to. So just to impugn that she was part of the drug game, when she's now testifying, when she has a Fifth Amendment right not to incriminate herself, and she's there saying, "Yeah, I don't use drugs. I'm going to testify anyway." I think I would give her the benefit of the doubt and say, "Okay, under these circumstances where you're, where you can be prosecuted."
She definitely didn't testify that she wasn't using drugs.
Raise your right
Yeah.
hand. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the
Oh, this is the other officer.
Yeah, I told you it sounds like the other officer. I have to poop. Should I go poop? Well, now this is going to be explosive.
Before you
Now,
begin, can you give us your full name, spelling each?
Peter Chang. First name is Peter.
is he? No, this, I don't think this is the officer. Let me see. Let's
Last name
see.
is Chang, C-H-A-N-G.
Mr. Nelson.
Thank you. Mr. Chang, by whom are you currently employed?
I'm employed with the Minneapolis Park Police.
Oh, this park police officer. Yeah, all right.
Are you a licensed peace officer?
Yes.
Could you please describe the training and experience that you have to the jury?
Training, I went through the Minneapolis Police Academy. Or prior to that, I did skills for a metropolitan state. Passed my skills. I went to police academy through Minneapolis. After passing the, I guess,
Go
academy,
poop.
I
Go
went
poop.
through a
Political
FTO
trucker.
phase.
Is that field training?
Yes.
Okay.
And that consists of 5 months. After passing that, I went on the street.
Okay. And you have you spent your entire law enforcement career with the Minneapolis Park Police Department?
Yes.
And how long have you been a licensed peace officer?
About to be my 4th year in August.
Were you on duty back on May 25th of 2020 in your capacity as a patrol officer for the Park Police?
Yes.
And did you ultimately respond to a call at approximately 8:00 p.m. to the park to the Cup Foods store?
Yes.
And can you describe for the jury how it is that you became a part of this incident?
I was stationed at a park close by. I heard 320 called out that they were taking out one, I believe. And then I heard a lot of background noises. And I heard dispatch asking for assistance. I was one of the closer squads, so I self-assigned to that call to assist 320.
Now, let me ask you, is it common for Minneapolis Park Police to assist on calls with the Minneapolis Police Department?
Yes.
Okay.
Oh, wow. It's common.
Your
I would say
jurisdiction
no.
generally is within the parks.
Yes.
However, you are able to back up or assist officers with the Minneapolis Police Department, right?
Yes, that's correct.
Let me ask you one quick question about your experience. You said that you went to the Minneapolis Police Academy, right?
Yes.
Even though you were looking to become a Minneapolis Park Police officer.
Yes.
Do the Park Police and the Minneapolis Police Department, you have the same academy?
Yes. Yes, we do.
Do you have the same field training process?
I believe so, yes.
And then do you participate in continuing education in service as a police officer?
Yes, we do.
Is
Yeah.
that also in conjunction with the
Good point,
Minneapolis
trucker.
Police?
Good point, political
Yes.
trucker.
All right. Now, after you, so you responded to the Cup Foods location,
Yes.
and can you describe for the jury initially what you observed and what you did?
When I got there, I initially stopped in front of Cup Foods and I observed the 2 officers, 320, across the street. So I drove my squad across the street and parked. I got out of my car, 320, one officer stated they were code 4. I guess got out of the car. I observed, I believe, Officer Kane with one of the individual who I later identified was Floyd. Floyd was in handcuffs, sitting on the ground, leaning against the wall, and Officer Lane was with 2 individuals by the car.
Now, let me ask you quickly, did you know either Officers King or Lane prior to this incident?
No.
Now, were you asked to do something at that point?
Once I got out of my car, Officer Kane asked me to identify Floyd in our system. So I just went back to my squad car and identified Floyd.
All right. And what happened next?
once I was in my car identifying Floyd, I observed Officer Lane and Kane is assisting Floyd towards their car, which was in front of Kafoots.
Now, can you describe where that would be Squad 320, correct?
I believe so, yes.
And can you describe where Squad 320 was parked and where you were parked?
320 was parked in front of Kafoots. They were on the northbound lane facing southbound. And then I was basically across the street on 38th. I believe the front of my squad car was facing eastbound on 38th towards Dragon Walk. Yeah.
Did you then move your squad car?
Yes, once I identified Floyd, I looped because I observed Officer Lane and Kane assisting Floyd to their squad car. I looped my squad car around and parked in front of their car, their squad car.
So your cars were sort of nose to nose?
Yes.
At an angle, right?
Yes.
All right. What happened next?
After that, I got on my squad car. I observed Officer Kane and Lane as pinning Floyd against the squad car, so I wanted to go assist. But once I approached them, Officer Lane told me to watch the car, and I did that.
And you did that?
Yes.
And then were you, where did you go in relation to the car?
The car was parked on 38th Street, so I basically went across the street to the car.
Okay. And what did you do then?
When I approached the car, I observed the two individuals that initially, when I arrived, I saw Officer Lane with, I guess, reaching inside the car. And I basically just told them to back away from the car, not reach inside or get anything from the car.
So you were monitoring what the two passengers were doing at that time?
Yes.
Was your attention focused on what Officers King and Lane were doing, or was it focused on what the passengers were doing?
It was more focused on the vehicle and the two passengers.
Okay. Now, at some point, did you observe another squad car arrive?
Yes.
And can you describe that interaction that you had with those officers?
I believe that was Squad 330. They arrived coming westbound on 38th. They parked in front of the SUV, and I basically just directed them towards 320, which they were in front of Kafoots.
Okay. Did you know the officers, either of the officers in Squad 320?
No,
Excuse me, 330.
I'm sorry.
330, not 320.
No, I probably met Officer Tao a couple of times, but no relationship.
Okay. And you'd never met Officer Chauvin prior to that?
No.
All right. Now, what happened next?
Basically went across the street, and then I assisted 320. And again, my main focus was just the car and the two individuals.
And as Mr. Floyd and the officers were across the street, did you notice any changes in the area?
Yeah, as there was a crowd, and yes, the crowd was becoming more loud and aggressive. A lot of yelling across the street.
Did that cause you any concern?
Concern for the officer's safety, yes.
Did you go over to try to help them?
No, because I guess my job was to watch the car and the two individuals that were by the car.
Did you know whether the car had been searched at all by officers?
At that time, no.
Were you concerned about that?
Yes.
Okay. Now, I am assuming that on this day you were in a uniform similar to what a Minneapolis police officer would wear?
Yes.
So you were fully uniformed?
Yes.
With all of the duty belt and all of the things that are on the duty belt, right?
Yes.
You were driving a marked squad car?
Yes.
And does your department require you to wear a body-worn camera?
Yes.
Was your body-worn camera active and recording this event?
Yes.
Now, have you had an opportunity at this point to review the footage that was taken by your body-worn camera?
I have.
And does that appear to be a fair and accurate representation of the things you observed?
Yes.
Now, in terms of as the crowd or the group of people were congregating around Squad 320, did you notice anything in terms of the tone or tenor of the voices of those people?
They were very aggressive. Yes. Aggressive towards the officers, yes.
Did the volume increase?
Yes.
And so how were you reacting? How were you splitting? How are you reacting to that?
Yes, I was focused on the car, but then it distracts me, and I was concerned for the officer's safety too. So I just kept an eye on the officers and the car and the individuals,
Okay.
passengers.
And if we can just show a couple of parts of your body worn camera. And if you just look at the screen in front of you.
Remember, everybody, this is what they were arguing this morning. Remember this morning they were trying to figure with this, but this is this morning what's
appear
coming
to,
in.
Be your body worn camera?
Yes.
And I note at the top right hand corner here, there is a date. What is the date?
May 26th.
Of 2020?
Yes.
And I notice a time here of 1:10:25Z. Do you know what that means?
I do not.
Okay. Are you familiar with Greenwich Mean Time?
No.
Oh, okay. So you don't know why the timestamp, you said you were, what time would you originally estimate that you were dispatched to this call, or that you were assigned to this call?
I'll say approximately 8 o'clock.
Okay. Obviously, there's a time difference here that says 1:10 p.m. You have no idea why that would be.
No.
Now, but it does appear to be your body-worn camera from that day.
Yes.
The same thing that you've observed before.
Yes.
All right. Then, Your Honor, I would
The man doesn't know about UTC.
admit Exhibit 1054.
Subject to the court's prior rulings, 1054 is received.
So we're going to watch about 3 minutes of your body camera here. Permission to publish.
Here we go.
Oh, 01. I was wondering if that would make sense. 01. Okay.
This is the Park police officer's body cam. Headed to the scene. So they're just showing him driving now.
Mm-hmm.
So code 4 means everything's okay. It's not. So this is what he gets to the scene. Floyd's on the floor. No problems. It's not a, you know.
All right, what's your name? George. George Perry Floyd. I don't know what's going on.
There's our witness from earlier today. That's the drug dealer's right there. That's the guy who's not testifying in the white shirt. That's the other woman. She's out the car, the one that was sitting next to George Floyd. The situation is not hostile at all. Now remember, they're going to redact this part of the video when he looks up George Floyd's information as per the motion earlier. Remember, the motion said they can't show the screen. So he's going to get back in the car and the screen's going to be black. Just so everyone understands what's going on. Now it's based on the court's ruling in the morning. That's so we can't see George Floyd's personal information. Now, when he types in George Floyd, that's supposed to be something black supposed to come over that
I
screen.
think they said they could just cut it out. Is what I think they said. See the timestamp. It jumps. Yeah.
Now, Officer Chang, does that represent that initial interaction?
Correct.
that
He's
you
an
had
alleged
with
drug dealer.
with officers King, Lane, Mr. Floyd, and the passengers of the vehicle?
Yes.
All right. And did you then, in fact, use your computer to enter in the name of George Floyd?
Yes.
All right. And after you did that, what happened next?
Again, I serve Officer Lane and Kane assist George Floyd to their squad car, which was in front of Cup Foods. So I got to loop my squad car around so I can be closer. And I got out of the car. And
Thanks, Miss White.
again,
Thanks
I
for the
serve
super chat.
Officer Lane and Kane. I was penning Floyd against their squad car, so I went to assist. But once I approached them, Officer Lane told me to go watch the car.
All right. I'm going to, if we could take this down, Your Honor.
That may be bad for the defense, because if Floyd was such a problem, you got an extra officer there. They're saying, "Go away, we got this." So that reads to what a reasonable
Again,
officer. Again,
showing you part of your body camera footage.
Yes.
And it appears to be the same date, same after you've run the information and looped the car around.
Yes.
And does this video accurately reflect what you saw and saw that day?
Yes.
I would move, Your Honor, for the admission of Exhibit 1055, which is an approximately 24-minute part of Mr. Chang's body camera.
Subject to the court's prior rulings, 1055 is received.
Permission to publish?
You may.
All right, Nate, I'm gonna have to bail for now. I got stuff to do, but
all
I'll
right.
talk to you later,
Well,
man.
listen, brother. I'll see you later. I'm only going to lunch, and then I gotta pick up my daughter. So we'll definitely talk later, bro. Thanks for watching.
You're best.
Okay.
So now remember where we're all at. The officers just run the
I don't want you guys to
information.
grab anything from the car, okay? Leave the car alone. Leave the car alone.
Yes, sir.
All right, now.
You just got to see. There's his phone.
All right. Just leave the car alone.
That's our witness from earlier. This is the woman who's on the stand.
How you doing?
Good. Good.
So understand this. If George
You gotta
Floyd was
take out
such
the
a
car.
threat, you still had this third officer
Cigarettes? You got your personal items?
who they got watching the car.
My hand. This is my phone.
Okay.
His phone in there.
Whose car is this?
That's his friend's car. A female name. I was trying to think of her name.
Okay.
Yeah.
Remember, the guy in the white is the alleged drug dealer. This is the guy who's taking a fifth. He
Who
is
is he
not
to you guys?
testifying.
That's my ex.
Your ex. Okay.
And I just seen him in the store, so he was gonna give me a ride home.
Okay.
I just came to get my phone fixed.
Now you get her story confirmed by the video. And now we know that she's his ex. So he didn't just meet in the store. That's his ex-girlfriend. And she was at the store. Let me get a ride home. Remember, she's like, we hugged up and all that stuff. You're taking a ride home. Ex-girlfriend. Oh, I'm sorry. Let me turn I'm sorry. I didn't mean to yell. Apologize, Joseph. Sorry.
He was giving her an hour trying to get us a ride.
Okay. Just stay put, all right? I don't want anybody near his car.
Is anybody gonna check my name? Because my daughter on her way here to get me.
All right, where's the ID?
I don't have it. I gave her my
All right, why don't you stand right there, okay?
They know who gave him the money. It wasn't us.
Okay. Did you guys give my partners their names or no?
Yeah, we already did.
You guys did? Okay. Did you write it down?
Yep.
You wrote down everything? Okay, stay put, all right? Let's see what my partner does.
Now here,
Yeah, he still won't get in the car. Just sit down, dude. Dude, they gotta push him
that
in
was
the
a
car.
this is a great clip for the.
What is he doing?
These are his friends saying this. These are his friends saying this. Listen to what they're saying. Listen to what they're saying.
Can y'all give him his phone now, please?
We'll see what happens, all right? You guys just stay put. Tell my partners to come back here.
Look, they still fighting. Hey. Oh man, what is he doing? Oh, they going all around.
This video is excellent for the defense. This is an excellent video for the defense. This is testimony without testifying, right?
You guys don't have your IDs on you?
I already gave him one, man.
Huh?
I gave it to him, man.
Why don't I see your ID again?
I gave it to him.
He has your ID?
Yeah. And I gave him my name because I didn't even get a purse or nothing.
All right, well, you just stay put here, okay?
I know one damn thing. Y'all better go ask Mike because it wasn't us.
Okay. Let's stay further back there, okay?
Huh?
Let's stay further back. What's her name?
My name's Shawanda.
Shawanda? Yeah. What's yours? What's your name?
William Ricardo, sir.
What is it?
William Ricardo.
Ricardo.
Yeah.
All right.
That's a lie. He's lying to the police. That is not his name.
Hey, man. Ask Mr. Adam about me. I should get some business with him, man.
Okay, we'll figure it out.
His name is not
Figure it
Ricardo.
They gave me some too. I told that shit up.
Give you some what?
Fake money, man.
Who gave it to you?
Told me somebody, I don't know, whoever the fuck asked for change or something to get some fuck ass cigarette, and the man told me, hey, that's fake. All right, cool. See mine, I told this shit up right. And he came out and started telling that dude, yeah. And I told him, and he told him to come back in the car, come back in the store. And he was talking, figure it out. Yeah, he was like, what the fuck? Where I'm gonna get some fake money from?
Yes, it's alleged that he gave a fake ID to the officer, and he obviously gave a fake name right now. His name isn't Ricky Ricardo. I'm not sure what the laws are in Minnesota. Yes, they should have played, the prosecution should have played this video. We should not be seeing this video for the first time now as jurors, as we all are. We're proxy jurors. We should have seen this video in the prosecution's case in chief, not now.
So Ricardo, how are you related to Floyd? How you know him?
He used to do security work at the Salvation Army, man.
How do you know him?
I don't know him. I'm telling you now, right there.
Okay.
You don't know Floyd.
So how are you guys together then?
We was getting a ride. Yeah.
Oh, okay, so you two are together.
No, I seen him in the store too, but that's my ex. You know
Okay.
what I'm saying?
How do
I
you
don't
two
know
know each other?
him.
He's
How
in
do
Floyd's
you not
car,
know
doesn't
him when
know
you
him.
say he's with you?
No, he was getting a ride with him too, and he told me come on and he'll give me a ride.
Okay. Just stay put then.
I don't need it because my daughter does.
All right, that's good.
Is this her right here?
I'll stay put, all right?
What's up? Yeah, because he was fighting. Yeah, because he over there fighting.
It's making it more difficult.
Right. Damn, that's. I know. I think he got shot. He was because he was falling asleep a little bit, and then when he woke up, they was up in the How you doing?
This is bad for the prosecution, people.
Right.
This is not good.
Officer, do you see
This is not good.
Individual on the left hand walking by?
Yes.
You had no interaction with her at this point?
No.
You'd agree that this is at 123 and 17Z of your body camera footage?
Yes.
The firefighter just walked by. That was the firefighter that testified earlier. From what it looked like to me, I'm not sure, but it looked like the firefighter testified earlier.
I spent my money. I paid for my phone. I was getting a laptop and it didn't work, so he gave me my funds back.
Okay.
You can come in and talk to him.
Okay, sure.
Now, these people are not under arrest. They are being legally stopped for reasonable suspicion of a crime. That's why the police are allowed to stop them, question them, and identify them.
Go ahead. Where is it? Go ahead. Go ahead. Let's make it quick.
So
Face
this
me.
is
Face me.
this is a legal stop and frisk. So they are stopping them to make sure there's no criminality afoot and identifying them.
No nothing. Then after all this is settled, you guys good to walk.
All this is settled. Can't y'all just ask him?
Let's wait. Don't you hear your friend talking? Yelling over there? I can see him yelling and talking. He's making noise.
To the store person.
I'm waiting for my partners. Gotta talk to my partner and see what's up.
Yeah, this doesn't refute any medical testimony. It doesn't. This is just shocking. I don't know how anybody can come to that conclusion. It doesn't refute medical testimony.
Yeah, I'm talking about I know the people in the store.
Okay, that's good.
212 has the closest available if you could start for an assault next door to 2313 Washington Street Northeast. There's a black male associate. Copy.
Officer, I'm just gonna look right here at the door, just see if I left any mark right here.
All right, let's get. That's it, man, Ricardo. Just the door. All right.
Yeah.
Nobody's come close to us, so right now we don't need a mask yet. So right now nobody's come close to us, so we're good with the mask.
Oh, this is that he called her?
Agreed. John, you're correct. Yeah. Nate the lawyer and Halsey handler, huh?
Yeah.
I don't want to convict people without trials. I don't know,
Stay put,
Florence.
guys. All right.
Maybe you don't watch my channel.
I want to be involved in that.
They did something for
All right,
him.
let's stay here, all right?
They did something because them motherfuckers taking pictures over there. Yeah, I'm on the phone. Yeah, everybody recording this shit, man.
330 EMS is at Portland and 36.
I don't know. I doubt it. Yeah, this guy here got us.
Copy. I was just giving you their updated location there. Stay around.
Oh, well, then I apologize. Sorry.
Walked in with him with Mr. Adams. Just, God
Let's stay put here. All right. Tell my partners and them done over there that they can figure things out. We'll figure things out. All right. Right now, we're grabbing an ambulance for your buddy, for Florida. Okay. So he might have hurt himself.
They hurt him?
He might have hurt himself. All right. Who knows?
Something happened. An ambulance here, everything. Can I just see what
No,
y'all did
this-
to him?
Shawana,
It all depends. I think
Stay
this is
over here,
bad,
okay?
but it might not be. It may not be horrible. This is bad, though. No doubt about it. This is bad. Just remember, the jury's first time in seeing this footage. This is the first time. So the shock, you can never overcome the shock and awe of seeing the footage for the first time.
Shawana. What was that?
I think y'all go one of the store guys.
Okay, let's stay put. We'll figure it out, right, Ricardo? I'm not giving you guys any problems, right?
Why is he going to hospital?
You see, he's got no control over these suspects at
Shawana,
all,
you're not
right?
helping.
They're just all over the place. They're walking. They could have walked away and left already, right? He
Once
wouldn't
our
know
partners
anything.
get over here, they can explain to you guys, okay?
Well, that's coming. That's coming, Sam. That's coming.
I'll try and get that.
They said it was coming yesterday. The defense literally said they have an expert going to say that today. So
Where's his phone?
It's in the car.
We'll take the car, okay? Nope, I don't want you reaching a car, okay?
It's right there on the seat.
He'll get to his car once he's done with that, okay? His car is not going anywhere.
Trying to get his phone? Yeah. Right here.
Don't go into a car.
It's the front seat, sir.
I don't want you guys going to the car. That's it. Well, once my partners come over here, you guys can ask, right? What? Just go straight, man. It's tight here. You guys good? Oh. I don't know.
Officer Chang, pausing the video for a second, you'd agree that the ambulance appears to be leaving at 1:30:21 on your body worn cam?
Yes.
I'm just waiting for the 320.
That shit bogus, bro. Such a man, you about to
Here's a book, man. Yeah, are you guys good with diesel? I'm gonna double check. There's a book. There's a notebook.
Want to get his phone? Yeah, in the car? Yeah, it's right down.
His phone. He's already gone. He doesn't need his phone. Is that his phone? Put his phone back.
Yeah, put his phone back. He's gone
or he went to the hospital.
Tell him where it is.
Are you sure?
Yeah.
Put his phone back. That's it.
You know him, bro?
Yeah. What's
Okay.
up?
You might call his family something. I want your family out. I ain't even.
What happened? Why he in the
So I didn't talk to them yet. You heard it.
Okay, you ran him though?
Nope.
No, that man took our name.
So supposedly your partner has his
What
ID.
happened to him?
Fucked up. All right.
That's your partner. Your partner needs it in order.
He took your ID?
Yeah.
He said.
They kept it put on it. They kept it.
What?
I tried to get him to get in the car. I tried. I told him he can't win. Go on, get in the car. I kept telling him that.
Okay.
Bro, you can't win, bro. Get in the car. Because I know you can't win.
They're good? Yeah. Okay. All
Two
right, you guys are good.
Two things I don't fuck with it.
Well, he said you two are good, but I'm not too sure about this.
Can I take Sylvia's car?
What?
That's Sylvia's truck. That's our friend Sylvia.
Okay.
Ex-co-worker. But let me try. If I get a phone, I can call her and tell her, sir.
Oh, the car's going to stay put right here until we figure it out.
Well, you better lock it because it's phone sitting right there.
Can I
Oh,
tell
oh.
Sylvia?
Just stay put. My partner's going to come back. I don't know what the plan is with the car.
Now they allowed them to leave, but he wants to stay there. This guy must be the dumbest guy. He knows he's got warrants. He knows, you know, he's been. It's like, why does he want to stay there? The guy's an idiot. So we all are on the same page. The prosecution knew this video was going to be bad for them, so that's why they objected to
You'd
playing
agree
it.
that the timestamp on your body-worn camera when the fire truck arrives is 1:32 and 50 seconds Z, correct?
Yes.
I didn't hear anybody call for it. Different call?
I would have played this video on direct. It doesn't, to me, it's not that damaging on direct. It's more damaging on cross seeing it for the first time than it would be on direct.
I don't think it's related. Okay. I think this car, when I got here, the doors were open, so they're involved. I don't know. So, is he on his 10 days? Or, I think they're done. Okay. Are you still red? Still red? Yeah. Yeah.
Yes, this is direct examination of the parks officer on defense.
If you would like MFD know that EMS needs the fire needs to go to Parking 36 station in the full rest.
I don't see how though, Sergeant Friday. Maybe you're seeing something I did. It's bad, but I don't think it's destroying anything. Sorry. I don't see how this video destroys anything. I think it's a bad video, especially them not showing it. But at the end of the day, it really doesn't move the needle on the incident itself, to be honest with you.
They need to go to 36 and park with this with the vehicle on full rest.
Yeah, I don't even know why they objected to this. I would have played this video.
Officer Chang, you'd agree
not
that
bad.
now the fire truck appears to be leaving, correct?
Yes.
Timestamp on your video is 1:35:06Z, correct?
Yes.
Yeah, this weekend's, but this is not
Are
destroyed.
subject to the court's ruling. Now, a few follow-up questions here, Officer Chang, for you. It seems to me that you're walking around quite a bit. Can you explain why?
It's pacing back first to make sure that I was concerned for the officer safety because of the crowd. So I just want to make sure that the officers were okay.
Did you observe other people at other locations besides where Mr. Floyd and the officers were?
You can say at least one at every corner of the intersection.
Did you observe people standing in the Speedway parking lot?
Yes.
And there were one or two people on the corner where you guys were?
Yes.
And at least one person across the street to the west, right?
Yes.
Southwest corner. Now, in terms of the general area, would you describe that as a pretty busy intersection?
Yes, traffic and foot traffic, yeah.
So a fair number of cars, vehicles traveling through that intersection,
Yes,
as well as a fair number of people on bikes or on foot walking past.
yes.
All right. Ultimately, did this pretty much end your involvement in this case?
Yes, that's right.
So you pretty much went back to your regular duties with the park police, correct?
Yes.
All right. Based on that, Your Honor, I have no further questions.
Cross-examination.
My notes for cross-examination said the crowd, you know, it says crowd, why did he stand over there with the witnesses instead of helping if the crowd was such a problem? And then why did he leave them and then come back if there was such a problem with the crowd and
Morning,
with Floyd?
Officer
I think that's what I would try to
Follow-up
attack.
questions for you. In the video we just watched, at one point when you were talking with Officer Tao, it sounded to me like you asked him still red.
Yes.
What is that? What you said?
Yes.
What does that mean?
If his body camera is still on.
And so you were asking him if his was on?
Yeah.
And that's because you had yours on still.
Yes.
And so, Officer Chang, when you're working for the Minneapolis Park Police, you go through the academy with city police recruits, correct?
Yes.
And at that point, when you're going through the academy, do you know whether you're going to end up in the park police or the city police?
When you first start the academy, you already know who. Sorry, you already know who you're, I guess, working for. Yes.
So, as far as you know, those recruits, you could be working with them someday in the future.
I guess on a straight, I mean, if we patrol the same area or precinct, yes. But
right, but when you start, you could end up being a city officer just like them.
No.
Okay.
So when you first start, I guess you already get the offer from the employer. So you already received the offer from Minneapolis Park Police prior to starting the academy.
Okay, now I got it. So when you're in the academy, you know you're going to be park police and the others may be city police.
Yes.
All right. But when you get out there on the streets, while you monitor the parks, you also have authority to assist with calls outside of the parks.
Yes.
So in terms of an average shift, let's say.
Yes, park police.
How often do you do this where you assist on a city police call?
Not often, unless we're close by. Unless we don't, I guess there's no calls at the parks, but we pretty much keep ourselves busy with the park system.
But if you self-assign to help a city call, you're not going to get in trouble from your supervisor for that.
No.
Because that's all part of your responsibilities. You're allowed to do that.
Yes.
And in fact, when you're doing that, when you're working in the park police, you have the same radio traffic. You're able to hear the same radio traffic as the city police officers.
Yes.
And in fact, I think we heard you refer to the city officers here as your partners, correct?
Yes.
So when you're there,
Those are police just for the
them
city parks,
as
just for the city parks.
your partners in working the scene.
They work in the
Yes.
parks.
And you would suspect that they feel the same way about you, I assume.
Yes.
Okay. With this particular call, you heard a request for backup, right, on this call?
Yes.
And because you heard some noise in the background, you decided initially to go lights and sirens.
Yes.
And to self-assign, I think was the term you used.
Yes.
Okay. And at some point, though, on your way there, you turned off your lights and sirens, right?
Yes.
Okay. And that was before you actually arrived.
Yes.
And when you arrived, I think we even heard as you're pulling up, the officers already assigned call code 4, correct?
Yes.
And what is your understanding, or back on May 25th of 2020, what was your understanding about what code 4 means?
Scene safety.
So it's under control, correct?
Yes.
All right. And when you got there,
So before he got there, they called the scene was safe.
you got out of your squad car, correct?
Yes.
And you see 2 city officers,
Yes.
and one who you later find out is Officer King
Yes.
is speaking with Mr. Floyd.
Yes.
And Mr. Floyd is sitting on the sidewalk against the Dragon Walk.
Yes.
He doesn't appear to be threatening in any way at that time, does he?
No.
Doesn't appear to be agitated or upset in any way at that time.
No.
So right there sitting on the sidewalk, he was pretty peaceful.
Yes.
Getting all that. Floyd was
And,
peaceful. Floyd was this. Floyd was that. Making sure you see he's running them down. And
when
yes or no
that
questions.
happened,
He's remember it's about the questions, not about the answer.
You never heard the officers call for a code 3 to other officers responding.
No.
So they did not call the code 3, correct?
No.
Code 3 meaning there was an emergency.
We're doing this question thing. You heard later there was a call for code 3 on the ambulance, the EMS, correct?
Yes.
But there was never a call for code 3 for the responding officers.
I don't believe so. No.
And when you arrived and got out, I assume you were trained to assess the situation, correct?
Yes.
And you did that as you're getting out of your squad car.
Was he going to a rough situation?
When you did that, did you hear Officer King ask Mr. Floyd for his name?
I did. Yes.
And you heard Mr. Floyd give his full name?
Yes.
Spell it?
Yes.
This is going to Floyd was compliant.
I believe so. Yes.
This is going to compliance.
You were asked to
state
run that
of
through
mind
the system,
too,
and
that he
you were
was
able to do
coherent,
that,
that he was
Yes.
being able to give his name and stuff. So that's what they're doing now. So if he was high on drugs, he's answering questions. He's giving his correct name, birthday, interacting with the police.
Observed as
that's what they're getting at.
Lane and King walked Mr. Floyd over to their squad car, correct?
Yes.
And that's when you decided to move your squad car over to that area, correct?
Yes.
And your intention there was to help those 2 officers with what they were doing.
Correct.
But as soon as you got out, they asked you to go watch the scene by the Dragon Walk with the 2 passengers.
Yes.
And you did that. You then walked back over to that location.
Yes.
And once you walked back over there, you really couldn't see what was going on with Officers Lane and King and Mr. Floyd in front of the cup foods.
I believe at that time they were still, still had Floyd against the car. Yeah. I believe during that time, yes.
Okay, so against the driver's side of their squad car.
I believe so, yes.
Going to his state to his perception, you couldn't really see them on the other side of the car. That's where they're trying to go to now.
Over by the Dragon Walk, you could no longer see what was going on with Mr. Floyd.
Yeah.
I mean, he couldn't see the neck was straight. He couldn't see what was going on. He has no relevant testimony to the actual incidents of the death. That's what they're going after. He couldn't observe it.
Was getting louder and more aggressive, correct?
Yes.
And but you knew that there were now 4 officers over at that scene, correct?
Correct, yes.
And so your main focus was on watching those passengers.
Yes, in the car.
And you assumed when you were doing that those 4 officers were okay over there because there were 4 of them, correct?
Yes.
And if they had radioed for help, you would have heard it over your radio.
Yes.
And they never radioed for help, did they?
No.
4 officers were able to control the crowd. If they weren't, they had another officer at the scene that would have helped them. That's what they're getting to. That was a good cross. And no further questions.
We're going to take a 10-minute break while we check the availability of the next witness. It'll probably be our last break before we break for lunch. And Counsel Chambers?
Oh, they're going to Chambers now. All right. So for the defense, I think today, before they go to the break, we had 2, I think, excellent videos put on by the defense attorney. The first video was of Floyd's prior arrest, taking pills, this, again, showing this kind of pattern of behavior, even though they're not supposed to use it. It just is what it is. It was showing a pattern of behavior. He gets arrested, he swallows pills, this. Good things for those. There were some good things with that, but then there were some bad things with that, right? Because the prosecution then got in that Floyd has this extremely high tolerance for pills, right? He's taking pills every 20 minutes. He's stuffing 7 in his mouth, he's all right. So that high tolerance then goes into, well, if he's doing that then it's kind of doing that now. I think the second video, I think it was informative because it shows that even Floyd's friends were concerned, like, oh my God, he's resisting this, right? Early in the video, even the alleged drug dealer, the woman he's giving a ride to, they're all kind of saying the same thing. Oh, why is he resisting? Why is he being so bad? So I think that piece of it was good for the defense, right? You get all that in, you get that perspective. But I think what's bad is at the end, because the defense is going to, and you'll see later today, is going on to the point where they're saying the crowd was a factor and was a negative factor that didn't allow them to render aid. But this witness, right? You have another law enforcement officer on the scene across the street, and if it was so bad where the crowd was was so overwhelming, then why wouldn't you call that officer over to help you? Why weren't the officers getting the radio? Hey, we need more units here, right? We got an angry crowd here, right? Showing, trying to nail down that, hey, this wasn't as bad as it was, right? And again, he did it through leading questions. This wasn't as bad. This wasn't as crazy. Look, you were across the street. They didn't even call you to walk across the street, right? They didn't call you to walk across the street. So it couldn't have been that. The crowd couldn't have been that bad. So I think that's where you're seeing the tension is. How much of the effect was the crowd? How much was not the effect of the crowd? So this is going to be interesting. This is going to be interesting going forward. I think the prosecution is still going to, for this witness, they're trying to throw this witness's way again, his observations. He was across the street. He didn't see when they were on the floor, right? He couldn't see that. So his testimony to that is irrelevant. He just was talking about what he saw across the street. So that's how, again, narrowing his scope, how important his testimony was at that time. So we got another 10 minutes. I'm going to use the bathroom. I'm going to put the stream up right here so we can all see it. But I'm going to be back in 5 minutes. I'm going to get to the drink, and I should be right back. So hang tight. We're just on a little break. If you guys got to use the bathroom, I suggest you do it now, because this has been pretty interesting stuff coming out from the prosecution to the defense. Yes, tolerance does change over time. But again, if he's popping one pill every 20 minutes, how much does it change? Does it change from him popping a pill every 20 minutes to now one pill kills him? Two pills kill him? I don't know. Again, that's what juries will decide. I'll be right back, guys. All right, everyone. I'm just getting my little lunch together before they come back. Can you do a video reviewing police brutality and actual rape and actual statistics based on sex and race? Is police brutality a racially motivated thing? There's an interesting study from Stanford that I am aware of that goes to this point. So I might be yeah, you know what? I may do a video on it. That'd be fantastic, actually. The Stanford study, I think, is probably that they went over 500,000 police interactions. So that's a damn good sample size from all across the country. So yeah, I'll point you guys to that. I think that's even on my preferred playlist, but I'll let that know. We got not murder. I don't know. I think you got the murder with the second degree assault. Hold on one second, people. All right, I am back. So I wonder who's the next witness going to be. Whew. So this morning, I think the defense actually has been doing a pretty good job. This morning was pretty good. This morning was pretty good. Let me see any questions. But I disagree. I'm not sure if that's to me. So if you want to ask me a question, just put at Nate the Lawyer. I'm just going to go up a little bit, see if I can see it. At Nate the Lawyer. Was that a study that showed parity to police killings? But no, it didn't show police killings. It was about police interactions with pullovers, when police, for car stops and things of that nature. It was they took a sampling of 500,000 car stops and ran through some statistical analysis. And they provided all their data too. So we'll look at it. But they showed that there was a statistical difference. There was a meaningful difference in the way, if you're an African American, for instance, that police interacted with you when they pulled you over. So it's well, that, and you got the New York studies, you have studies all over the country, and all the studies show the same thing. It shows that if you're a minority, it's more likely, even if you commit the same crime, it's more likely you'll get stopped, you'll get searched, and that police will be more aggressive towards you than if you're white. And that's just a fact that the numbers present. You know, if unless people you know, that's a realization I think we need to accept, because every study has shown that to be the effect. But it's not, is it happening? It's why it's happening. And I think there are a whole bunch of different scenarios about why it's happening. Is it happening, you know, because police have quotas? Is it happening? There's so many different theories about why it's happening. But the fact that it is happening, I think is something that can't be ignored. Nate the Lawyer, did DV know that he was assaulting girlfriend? I don't know. Did DV know he was assaulting his girlfriend? I'm not sure. I don't know. Sorry, you gotta ask another question, or ask it. You know, rephrase it, I should say. If it doesn't fit, you must acquit. That's true, but I still think. See, I think a lot of people don't realize what we got here. Right? We got. All right, so let's just understand this, people. The state isn't trying to prove, right? They're trying to prove an assault. An assault, I think, is a lot easier to prove than a murder, right? Everybody in this chat has got to agree. An assault is a lot easier to prove than a murder. So they're trying to prove an assault in the third degree, right? So they have to prove that he intended to harm Floyd, right? By either punching him, kicking him, or whatever. They're proving an assault in third degree. Now, for those of you naysayers out there who don't believe that, right? Who don't believe this, I can pull up, which I'll do right now, just so we're all on the same page. I'll pull up right now the amended complaint. Derek Chauvin's amended complaint. Let me do that for you guys, so you guys can say I'm not just making this stuff up, because for some reason people think Nate's just making it up. So let's just go through this while we have some time, so we can all understand what the prosecution has to do to win right? The murder, obviously they would love to prove, manslaughter. They want to prove it all, but the I think the liability here for Chauvin is simple assault. So let's look at it. Let's look at it together as an academic way. Now I need you guys to take away all the whole, second degree murder is 40 years and manslaughter is 10 years, and it seems more likely it's just 10. But don't look at it from the perspective of the punishment. Look at it from the perspective of what needs to be charged and what needs to be proven, because this is one of those rare occasions where the higher charge, you need less to prove the higher charge than you do to prove the manslaughter, if that makes sense. Think about it. It's easier to prove an assault than a manslaughter. It's easier to prove an assault than a murder. So that's how I need you guys to, just those simple concepts that I think we can all agree with to understand. So now let's look at the amended complaint. The amended complaint means, let me stop screen sharing this. The amended complaint, what an amended complaint is they filed the complaint the first time and then they added charges. So let's look at the amended complaint so you guys can see exactly what the prosecution is trying to prove. So here it is. The amended complaint. Now, this is from the court's website. So this is, again, just from the court's website. What I'll do too is because there may be some issue with this, right? There may be some issue with people saying, Nate doesn't know what he's talking about, right? So I like to just, let me make sure I'm going to put the link to this document in the chat so you guys don't have to trust me. You guys can click that link and look at the document when you're looking into yourself. I'm going to make sure they're not coming back yet. All right, they're not back yet, so we can go through this real quick. I'm going to put it up full screen so we can all see it together. Okay, so this is the amended complaint for Derek Chauvin. Sorry, I keep saying Chauvin, but it's Chauvin. Now, here it is, count 1. This is felony murder, right? Unintentional, so he didn't have to intend to kill him while committing the felony. Now, if you read through all this, right, Michael Derek Chauvin caused the death of a human being, George Floyd, without intent, so he didn't intend to kill him, to effect the death of any person while committing or attempting to commit a felony offense. And then it gives the exceptions, other than criminal sexual assault, blah, blah, blah. But here they list the underlying assault, namely assault in the 3rd degree. So based on the amended complaint, right? Based on the amended complaint, they are trying to prove that they committed the underlying assault. What they are trying to prove is they're committing the underlying assault led to the death. So I understand people are saying, well, they got to prove he intended to kill him. That's just not accurate, right? Look at the amended complaint. They're telling you. Now, a couple of people say, well, they didn't charge them with an assault, right? They didn't charge them with an assault. That's true. They didn't charge them with an assault. But that doesn't mean they still have to prove the underlying assault to get to felony murder. So that's what the prosecution here is trying to do. He assaulted the officer. I mean, the officer assaulted him. He wasn't justified in their assault, and he led to the death. They're coming back, so let's go back. But I think that's important for all us to know.
Your Honor, for the record, the defense recalls Officer Nicole McKenzie.
I like hearing your perspective. Oh, thank you. Thanks for the $5. 5 pounds, I should say. 5 pounds. So they're recalling this. They're recalling a witness.
We're just ready to get. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth.
Yes, Your Honor.
Now remember, this is the medical, their medical training
Spell
officer.
your full name again, so the court reporter has it.
Nicole, Nicole, last name McKenzie, Mackenzie.
Yeah, Mr. Nelson.
Thank you. Good morning, Ms. McKenzie.
Morning.
Officer, I apologize. I'm sorry. You've previously testified in this case, correct?
I have.
And just to refresh the jury's recollection, what is your role again with?
Yes, she has been. Yes, she
I'm the
testified
medical support coordinator for the department.
for the prosecution.
And in terms of,
Actually, could you take your mask down?
Yes, sir.
Okay.
thank you. In terms of the training that you provide to officers, fair to say that the training consists of both academy training and veteran officer training called in-service.
Yes, sir.
And in terms of the training that your department provides, does your department provide excited delirium training to officers in the academy?
In the academy, yes.
And that's not something that routinely is given to the veteran officers.
Correct.
All right.
Excited delirium.
Now, you understand that Officer Lane, who is a part of this case, recently attended the academy.
Correct, yes.
And he would have seen the materials that the Minneapolis Police Department provided relevant to excited delirium.
Yes, sir.
And you've had an opportunity and you've reviewed the PowerPoint presentations that are prepared in that regard?
I have.
Do you want the instruction?
Members of the jury,
You're about to receive evidence regarding excited delirium training that was received by Officer Lane at the Police Academy. This is being offered for the limited purpose of explaining why he used the phrase excited delirium on May 25th, 2020, and what that meant to him. This is not being offered as state of mind or knowledge of the defendant, since we have no indication in the record that this defendant, Mr. Chauvin, took this training. So accept it only for that limited purpose regarding Officer Lane. Mr. Nelson.
Thank you. It's just going to show you, this has been pre-marked as Exhibit 1053. Does this appear to be the training materials the Minneapolis Police Department provides for officers, cadets in the academy?
It does.
Does it, and just skipping through, does this appear to be a accurate copy of that?
It appears to be so.
And I'll just kind of scan through fast. To be pretty much the entirety of that training?
It looks like it, yes.
Okay. And can you just describe for the jury generally what excited delirium is as you train it?
Certainly. It's a condition that's a combination of a variety of different medical issues that are happening at the same time. This could be something like psychosis, I'm sorry, agitated delirium. It could be a pressurized speech, incoherent speech, superhuman strength, hyperthermia. They could all be present.
And does the Minneapolis Police Department train cadets? What types of things cause excited delirium?
In a general sense, yes. It's a combination of pre-existing factors. It could be cardiovascular disease, also illicit drug use, and also mental health diagnoses.
Okay. And
Agreed.
in terms of the signs that officers are trained to look for, could you describe what those are?
Yeah, we do use an acronym to correlate with that, and we use the acronym of not a crime. So there's a varying different things you might see if somebody's presenting with excited delirium, like the person, because they are experiencing hyperthermia, meaning excessive temperature, they might be removing their clothing.
Now remember, the state already had a witness, a doctor, testify that Floyd didn't have excited delirium. He wasn't showing signs of excited delirium. So just be mindful of that.
And if I could reference my materials, I can go through a little more in detail.
So for purposes and subject to the state's objection, the defense moves
Yes.
to introduce Exhibit 1053.
Subject to the court's rulings, 1053 is received.
You see the first letter of your acronym, not a crime, before you.
Yes.
And what does that stand for?
The patient might present as naked or sweating, removing their clothing.
Okay. And the second slide being, or excuse me, the next letter being O.
Yes, and that's objects exhibiting violence towards objects.
Okay. T,
Is tough and unstoppable.
that's what you described as like superhuman strength.
Yes, sir.
A,
The onset is acute,
what does that mean?
and that's where somebody will say the patient just snapped.
So it's rapid or fast.
Right.
C,
The patient is confused, might be speaking incoherently.
R,
Resistant.
and define that.
That the person will likely not be able to, they don't have a capability about them to respond to commands, to comply.
Okay. And I,
Incoherent.
and how would you define incoherent in this sense?
If somebody's like experiencing some level of psychosis, they might be talking about complete nonsense. Their words just don't even make sense. And there's really no dialogue you can have with them, meaningful dialogue you can have with a person.
Okay. And M,
That'd be mental health. The person or callers have some kind of information that leads to believe there's some mental health issues going on.
okay. And E,
And that EMS should be requested early.
it's fair to say that if an officer suspects excited delirium as occurring with a suspect, there are certain steps that they are encouraged to do, correct?
Correct.
Can you define what an officer should do if they encounter a suspect they suspect is suffering from excited delirium?
Definitely get more resources started because you might need more resources than you would think. And then also having EMS stage at a safe distance away until the situation's under control.
And obviously attempt to control the subject
Correct.
through physical restraint.
Yes.
It's fair to say that once a person is in handcuffs under the excited delirium, you train officers to put that suspect in the recovery position. Agreed?
Correct.
And what would be the purpose of bringing EMS on scene?
Because people that are experiencing the excited delirium syndrome, they can rapidly go into cardiac arrest.
And that's how you train Minneapolis police cadets, correct?
Correct.
Now, again, as far as veteran officers, they may not see this particular training materials, correct?
They would not.
But is excited delirium a subject that is discussed in in-service trainings generally?
It has been in the past, but that was not with the medical support team.
So in terms of use of force or other questions or other areas of training?
Correct.
Okay. Your Honor, I have no further questions.
Mr. Frank.
All right, let me just see if I can get my notes out here. I put on cross, I would go through the signs of excited delirium, match them to George Floyd. Did George Floyd do this? Did George no excited delirium? He wasn't existing, or everybody existing arrest is not excited delirium, and the recovery position. I would kill on that. He would put him in not the prone position. Let's see what he does. But that's what I predicted the cross is going to be.
The basic training on excited delirium with cadets or recruits is what to look for.
Correct.
And then secondly, what things they can do.
Correct.
And one of the things that they are told to do is to put the person in the side recovery position, correct?
That is correct.
And that's to help facilitate breathing.
Yes.
Boom.
Because excited delirium, if it exists, could compromise proper breathing.
Boom.
Absolutely, yes.
And officers, both in the academy and veteran officers, are trained on CPR.
Yes.
And so they are also trained that they have an obligation if someone becomes pulseless or unresponsive to initiate measures such as CPR.
Yes, sir.
There it is.
And that would be, and an officer like Mr. Chauvin would have received CPR training on a regular basis.
Yes.
You were asked about the acronym to help identify potential markers of this condition.
Yes.
Would you defer to an emergency room doctor on whether someone is actually experiencing excited delirium?
Absolutely. It's not our place to diagnose that.
I have nothing further, Your Honor.
Anything further?
Mm.
Thank you, officer. You are excused now.
So, matter of fact, the excited delirium, they're not even able to diagnose it.
Your next witness is available after lunch. What time?
12:30, 12:45.
All right, members of the jury, we're going to take our lunch break and let's reconvene at 1:15. We'll see you then.
Oof. All right, people. Let's close this up. All right. So this is the morning session. I gotta say, this morning session was pretty interesting. I think the defense started off. I think let's just call it what it is. Starting off with the video was a power move, right? That video for the 2019 arrest, 2019 arrest 2 years ago, was a power move. I think they started off very strong. I think this last witness wasn't that great for them. I think he got in. I think on direct, they got into the excited delirium, but it really doesn't make. All right, let me go back. Let me explain, because I'm going to give you my conclusions, but not telling you why I'm thinking it. First, on direct, on the People's case, they had an expert police surgeon who wrote the book on excited delirium come in and say, here's the things. And obviously George Floyd was suffering none of these excited delirium effects. Now you have this woman come on, and she's saying, okay, we do train them for excited delirium, and we only train the new officers. We don't train the old officers, just train the new officers. This new officer, remember, and you have to remember, look at it from the totality. This new officer at the scene holding George Floyd down. Remember, they were telling him, maybe we should roll him over. Maybe we should do this, right? The officers were trained in excited delirium, right? Because there's only the new officers. So that, I think, may have been a mistake in having this witness come on to testify about the new officers in excited delirium, because the new officers were the ones, hey, maybe we should turn him over. Maybe we should do this. Maybe we should put him in a recovery position. That gives a little bit more credence to hold on. And the fact that they're not trained to put them in the prone position, but the recovery position, again, it didn't end strong. It started strong, but it didn't end strong. The two videos they got in today, I think, were good stuff, because it does give the jury something to chew on. But at the end of the day, you still got to overcome the fact that this is, a simple assault, because again, that's what all they got to prove. You still got to overcome the fact that you got the top doctors in the field saying that he was the cause of death. And I think you still have to overcome the justification. But I think Nelson is fixed on the justification piece, because he knows if he wins on justification, they get nothing. Justification, just so everybody understands, justification is an absolute defense. You get nothing. You get no murder. You get no assault. You get nothing. He was justified. So the justification here is a powerful thing. And I think Nelson is trying to play that, because if you get that, you get everything. Instead of playing, well, this is why it's not manslaughter. This is why it's an assault. No, he's going for the whole bomb. And the whole bomb is, if I can get them to say that this was reasonable and he was justified, then I got it. Here we go. Missed a redirect chance. Should CPR be initiated before the scene is secure? That would have been good. That would have been good. But then you go back to, if the scene wasn't secure, why hold them there, right? Why hold them there? Especially non-responsive. You know what I mean? So it's possible. And you had another officer there that could also help. If it was really not that secure and you needed to give somebody CPR, you should start the CPR, but then you have another officer you can bring over there. So it opens up another bag of worms just by saying that, hey, I'm not doing it because the screen is not secure. I'll answer a couple of questions. Again, super chats get preference. Just tag me at Nate the Lawyer so I can see them. Super chats with preference, and I'll just go through the chat and answer whatever questions that anybody has, if I can. Again, I'm not a Minnesota attorney. Nate the Lawyer, your opinion. Can a prosecutor or defense in this process of trying to make a complete case present weaker evidence, therefore undermining the stronger aspects of their case? Yes, because you want to put your best foot forward, but not all attorneys do things in the same way. Some attorneys want to try to hide bad evidence. Some attorneys want to confront it. I think when it comes to the prosecution, they have to give all their evidence. So the prosecutor can't hide bad evidence, right? If you have evidence, it's called a Brady violation. If I have any evidence that may show or even tend to show that the defendant is innocent, it will be an ethical violation for me not to turn it over, right? So it's an ethical violation. So the prosecutor can't do that, but the defense is not under that obligation. So the prosecutors can't hide evidence, but the defense, it's like, yeah, I don't have to prove the state's case. I just have to defend my client. At Nate the Lawyer, no one is getting naked. Nate, this is the weirdest porn ever. When is it starting? Not today. Not today. $2 for butt hurt pills. Thanks for the morning amusement. Just give me a call today. Gotta head out. All right, cool. Thank you, Drat. I'll definitely, yeah. No, you got my number. Just ring me. Ring me whenever. Thanks for the $5 super chat. So at the end of the day, people, it seems like there's no more questions. But at the end of the day, understand this: we're trying to prove an assault in the third degree, right? Do we see an assault here? We're also trying to say it wasn't justified. Do you believe? Now you can believe this wasn't an assault, but just understand, why do you believe it's not an assault? You can believe this was justified. Understand, why do you believe it's justified? And understand, you have to believe it's also justified that they held him down with the knee on the neck for the 4 minutes that he was unresponsive. That also has to be justified. So it's not just, yeah, he was resisting, because I think a lot of people have this weird notion that if you're resisting at the beginning, we can hold the knee on the neck for a whole hour. Just imagine if someone's resisting, right? And I have to put my hands around their throat and they're resisting. But then they stop resisting, right? All right, and put their hands behind their back and we handcuff them. And I can't just hold my hands there for the next 8 minutes because they were resisting earlier, right? That's not reasonable. And that's what we were talking. That's essentially what we're talking about here. Was it reasonable for this to happen? So we're looking at the reasonableness all the way through the event. And then the last, obviously, was he the cause of the death? Now that's going to be, I think, harder for the defense to overcome because you got world-renowned experts that say he was the cause. So, I'm not saying it can't be overcome, but that's something that you'd have to overcome. And think about the standard of what reasonable doubt is. Are you just going to dismiss all the top experts in the field, everybody saying the same thing? The cause of death was a police restraint. As a cop for years, the problem is there is no competing alternative. Accountability and reform is best achieved when you do not have a captive audience like the public schools do. It was a good point. Interesting point, but very good point. The 4 minutes is a hard problem for the defense to address, of course, because I think a lot of people, we can all agree. I think reasonable minds. Let's take out BLM. Let's take out white supremacy. Let's take all of that out, right? Because at first, this is not, the case has to do with race, I think, in a philosophical sense, right? But this case about this use of force is not a case about race, right? This is a case about a cop who used excessive force. He's not being charged with a hate crime. He's being charged with assault as a felony murder assault. So that's what we first need to just pinpoint there. So we're going to take the race piece out of it because it's not, I don't think it's relevant to the conversation. Nobody in this trial, right, for the past month has even mentioned the word race, right? So I'm not saying this because I'm just want to be, I want you guys to think that I'm just so oblivious to it. It's just that it's not relevant to the trial. No witness is going out there and said this Chauvin's a racist and he killed him. No, nobody's saying that, right? Because that's just not accurate. And that's no evidence that has been introduced to trial. So this instance, we're talking about a legal technical matter about what's happening. So I want to make sure we're clear about this. Second is that Chauvin may have been justified in using force to effectuate an arrest. That is, he was a police officer, can use force to arrest people. That's just plain as day, right? Sometimes they have to, especially somebody who's resisting. That's another fact that we have to consider. Another thing is that Floyd was resisting. I know the BLM people are going to say, so what? But Floyd was resisting. And that resistance needed to be overcome to effectuate the arrest. That's something that the video shows, right? We can't overcome that. But that resistance had been overcome. But so now you have someone who's fighting at the beginning, who stops fighting, gives up. What do you do at that point? Do you continue the fight? Because the force you use to overcome that is no longer necessary at that point in time. So you're there for another 8 minutes. Now, even if you can say, okay, the first 5 minutes is good, you still have to account for 4 minutes when you have a handcuffed, unresponsive, no pulse individual on the floor who's not moving. And you kept the same level of force on that individual. That's a problem. That's excessive. That's excessive no matter where you go. That's why everybody's saying that's excessive. If you can overcome that, then I think you've overcome the assault. But I think in that moment, when he's literally got his knee on a dead body, that's where I think you don't have. That's why I think the assault. That's why I think you have the assault. Let me see. Just wanted you to know I've got something in my eye. That's why I'm blinking so much. All right, thanks, Bill. Oh no, one of my eyes are actually, I'm blind in one eye. So if that's for me, yeah, one of my eyes are gone. So I just want so again, I'm just really trying to draw it down because I understand a lot of people. There are a lot of different theories out there, a lot of different this. What does it have to prove? But at the core of this issue is, was this officer justified in using this amount of force to subdue this suspect in this way all throughout? Right. If I'm in a bank robbery, we're all shooting at each other. Boom, 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 boom. Right. Then a suspect throws his gun out and puts his hands up and walks out and says, "I'm giving myself up." The cops still shoot. That's unjustified, right? The guy's giving up. Why are you still shooting? He may have shot before. You can't just say, "Well, the guy was shooting 5 minutes ago." No, if he gives up and puts his hands up and it's coming out, and you shoot him, that's an unjustified use of force. He was not resisting. Right? That's the same thing. Again, that's the same thing that the prosecution is putting forward here. Instead of a bank robbery, he's just, he's finished, and they kept using this high amount of force. That's what you got to understand. Felony murder assault, third degree blossoms into murder with strict liability jurisprudence. Got to be doubtful for the cop. Listen, I showed you the complaint. I've showed you the charges. They are charging him with felony murder assault. Weird. Doesn't make sense. Shouldn't be allowed. No, I think no other country in the world allows it. And most jurisdictions in the United States don't allow this. But Minnesota, you take the law as it is. Minnesota, it seems like if you kill somebody after an assault, you can go to jail for life. It's just the way the world works over there. Nate, the lawyer, were there any officers injured in the way? Were there any of the officers injured in any way from struggling or resistance? No, there doesn't seem to be any report of that. I've not seen anything like that. Would that be assault on a corpse? Well, if he was pronounced dead, was he dead? And I would say it's assault because unless you're saying that he killed them with the knee, but then he stopped let's just be clear. Floyd stopped resisting about a minute in, right? Because he was face down, all the officers were on top of him. So he had already stopped resisting. He passed out about 2 minutes later. And then for 4 minutes after he passed out, they kept the knee on his neck. So he may have died. And remember, the doctor showed me he took his last breath and he'd stopped breathing after that point. So now somebody has just died. We're a minute in, right? But less than a minute, we're 30 seconds in. Somebody checks his pulse. This person doesn't have a pulse. The person's not breathing. Another officer says they passed out. Do you give CPR or do you keep him in the prone position, handcuffed? If I think a reasonable officer somebody's checked his pulse, he has no pulse, he's not breathing, he's passed out. Would a reasonable officer give CPR or would a reasonable officer continue to stay on his back? That's a question for you. And I'm not saying it to be quirky, but I'm just that's what we're talking about. What's reasonable? Could they have saved his life? I don't know. They may have could have done nothing. But do you give CPR? They have defibrillators in the car. I know they have that. We had defibrillators in our car when they first came out. They got defibrillators. Somebody's checked this. If the argument is, well, it can't be because the testimonies come out. The officer checked his pulse. Nate, question. Even if it's reasonable that Floyd died of an OD, the extra 4 minutes is a problem, correct? Yeah, of course. Of course it's correct because you have a duty to render aid. And this is what Nick Recchietta says. Nick Recchietta says that he understands. Nick Recchietta says he believes the manslaughter in the second degree is a great charge because then you got the duty to, you didn't render aid, somebody checked his pulse. So that I think, if anything, I think people don't agree with the assault because of the high amount of time, but I think we can all agree the manslaughter in the second degree manslaughter is right on point here. That would be, I think, the most appropriate charge. And I think you may even get to third degree, but it's the manslaughter in the second degree is right on point. Boy, questions are coming in hot and heavy now. All right, so I got a couple more minutes before I got to go. Nate the lawyer, can an officer pronounce him dead? No. I also think that the defense already covered the subject. Regaining consciousness and continuing to fight. Yes, but that's risk. So you got to understand the difference between risk and threat. Just because something's a risk doesn't mean it's a threat. All right, explain. I got 10 people. That's a risk, right? But if those 10 people are, just doing nothing, I'm talking to them, they're not a threat, right? They're not a threat to me. They're not aggressive toward me. So just because something is a risk doesn't mean it's a threat. So yeah, it's a risk that he can recover and continue to fight, but that's not. But there's no threat. So we don't use force based on risk. We use force based on threat. If we use force based on risk, then I can punch you before you became a threat because you're risk. So if I'm 5'10", 5'11", if somebody's 6'10", that means I can punch them because the risk they have a risk of being able to harm me. That's not the way it works. It's not about risk. It's about threat. I hope I explained that, but that's law enforcement in a nutshell. Risk is you prepare for risk, but you respond to threats. Nate the lawyer, did he stop resisting because he decided to stop resisting, or did he stop because he was restrained to the point where he was unable to resist? It seemed to me that both. It seemed to me that he stopped resisting because he was restrained to the point where he couldn't resist. And then at a point, he was just unable to resist, right? He was unconscious. So once you have the resistance, once you've overcome the resistance, even their manual, because we all talked about the training, even their manual says you should put them in a recovery position. Again, I don't think, no one here can deny that he stopped resisting, maybe about a minute into the 9-minute struggle. A minute in, there was no resistance after that. Just watch the tape, right? A minute in, he stopped resisting. Did they check? He did check his pulse, but he used his thumb. Doesn't matter. Just imagine that this is true. Somebody's unconscious. You check their pulse. You find no pulse, and nobody does anything as an officer. And you say, "Well, I checked on my thumb." So you're supposed to check it again. If you feel no pulse, that means something, right? Then he should have said, "I felt no pulse." He should have said, "I didn't do it correctly." But the fact is, Chauvin didn't know how he didn't know he did it correctly. Didn't know he did it incorrectly. Someone's saying, "I don't feel this guy's pulse. He's passed out. Maybe we should roll him over." Those are damning things to say. Think about it. Bill, I understand where you're coming at, but think about it. You're right. Technically, if you're checking with your thumb, you're wrong. But he's saying, "I checked for a pulse. I don't feel a pulse." Does that mean you do nothing? I'm making the counterpoint. I'm sorry. And again, I don't mean to be combative. I'm just answering the questions based on the evidence that's been presented. So I'm not trying to be combative. Nate the lawyer, can officers pronounce him dead? No, officers can't pronounce him dead. That's why they have to continue to do, chest compressions and stuff to keep him alive. Also, I think the defense already covered the subject. Oh, we talked about that already. Sorry, I went up instead of down. I'm currently a police officer, 9 years experience. I really enjoy hearing your experience as a lawyer and a cop. Good for others to understand. Thank you. And I got a nice little law enforcement group that follows me. I just, a lot of people don't know how it is to be in law enforcement, right? They don't understand that the law enforcement officer, your mistakes lead you to jail. That's what's going on with this other case in Minnesota, right? The officer grabbed the wrong tool, right? Now, it was her fault because she put her stun gun on the same side with her firearm. That's a huge no-no. Why? Because if we all know as officers, when I don't want to curse because of this, but when blank hits the fan, things get hot. You start reacting. You don't think, you react. So what they tell you to do is that on your dominant hand, like my right hand is my dominant hand, my firearm is on my dominant side, because when stuff hits the fan, I need to pull that out. I got to go to it quick and respond, right? I got to go to it quick and respond. So that's why it's on the dominant side, my dominant hand. The taser should be on my non-dominant hand, because if I'm reaching for a taser, that means I have time to think and pull out a taser, right? And pull out a taser, pull it across, and then respond. This officer, from what I'm understanding, had both on the same side. So she had a taser on that side and she had a fire on that side. So when she went to tase this guy, she grabbed, because again, she's in a fight now, pulled up. And if you're not looking at it, a taser and a gun feels the same. They're pistols. They're essentially pistols. They feel the same. She pulled it out and she's pointing a gun. She's screaming, tase, 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 to let all the other officers know I'm about to tase this guy. But she had her gun. Mistake? Yes. Criminal? That's for you guys to decide. Let me see. All right. Does anybody have? I'm going to have to go, guys. But I'm hoping this was helpful. I'm hoping this was informative. And you know, again, this is tough stuff. This is tough stuff. But it is what it is. Here it is. But you could punch him first if he's resisting you, possibly, right? Possibly. It all depends. It's not if somebody's resisting you, I can just punch them. That's what reasonableness is, right? Reasonableness. If somebody says I'm not going and puts their hands behind their back and says I'm not going with you any, officer, you can't punch that guy, right? You can't punch that guy. That's why a lot of officers and a lot of training in some departments are mistaken. They'll say something like you should be one level above with the person is. So in other words, so if a person is fighting you, with their hands, they say you should have your aspeton, you should have pepper spray, or even your now I forget the name of it, but even your taser. But if the person's running away, they're resisting too. You don't tase somebody who's running away, right? So that's what we're talking about. It's proportional amounts of force to what you need to overcome. Whatever I need to overcome, the force that's being used, that's what I can use at the minimal level. You can use your gun to overcome all force on the street, but that's unreasonable. It's supposed to be the minimal amount of force needed to overcome this situation. Somebody talking trash, I don't pull out my gun, right? It's going to overcome that force, but it's unreasonable. That's how they train law enforcement officers to think. All right, people, that was my stuff today. I got to get out of here. I got to get out of here because I got some stuff to do. I hope you guys enjoyed this. I'm going to try to see if I can do this again tomorrow. I might not be able to, but if I can, I hope you guys enjoy. Don't forget, like, share, subscribe, hit that like button. I hope you guys enjoyed this. And I know this is very, very sensitive. I know this is tough, but I want to make sure that you guys understand, just from the legal perspective, what's going on here, and just being able to make a more informed decision. No matter if this cop is got off, or if he gets off, or if he gets convicted, I think the understanding that we're all learning together makes this an easier process when more of these things happen. So my name is Nate the Lawyer. I will see you next time. Thanks for joining me.